giving us
What?
what is the page? What should we go? Enter part shop together. Only one hearing. What should just now enter counter?
Yes, what can be done?
I am saying these matters after your results for 30 by 22 mentioned. So these are extremely urgent. Consider the urgent this matter. Is the you mentioned before a lot of things.
Hearing matter.
Wait for some order which is not because objectionable by others. Both the sides.
Okay, so to be mentioned it. So from this side I am taking mentioning yes. Restoration application. Upgradation, what is the urgency? That has been
whereas I had paid back the loan amount. This number could directed them to find it. Till now they have not. Even if one of them find it, and that is correct. What is the where is the law? They are still
another direction for extension of affidavit is to be passed. নিন এটা দিন একজন নিন ওখান থেকে হ্যাঁ
after seeing the what will say this now the accent of so one thing debate change the entire document and they claim that it's a premium yet clear can be possible option you have changed the document before that so what they did to find this equation and they are saying that over there I am not getting my money. I am not. I can't.
You are for the respondent. Who is for the petitioner? We give it. The office has not done or petitioner has not done. So now in a disposal of matter, I am to grant liberty to the petitioner to make necessary correction in the cost title in terms of the order passed in an interlocutory passed. Need to be mentioned actually. Pension matter. As a pension matter, okay, I did to pension matter. Have you given notice to other side? 5 to in 5 779. Yes.
Lord, this matter is ready for hearing upon completion of exchange of affidavits. Lord, kindly fixes a date anytime after my lord.
No date here. Don't date. What is your urgency?
The urgency is, my lord, I am supposed to be transferred to one college. There is only one vacancy in my subject. If, my lord, this vacancy is filled up in the meanwhile, my petition becomes infructuous.
So why you did not pay for interim order at the time of admission when your matter was filed?
The matter is of 2022.
2022. Then you didn't find a urgency that they may fill up. Now in 2025, you realize that they may fill up the post.
Absolutely. I consent to whatever is for lordships, my lord, but this is a changed brief. It came to me at the stage of final hearing. My lord, kindly takes it up for hearing the exchange of. Kindly includes it in the list, my lord.
How many 913 matters have been included? 913 matters have been included. Except this, there are many other bench. You try your luck before another bench, what can be done? 913 matter. I am to mere inclusion. Mere inclusion in the list will not suffice. Court is to dispose of the matter. If for your client satisfaction you want the, somehow get it enlisted, that is another aspect. But court is to dispose of the matter.
Kindly keeps it in the list.
And I have stated that if I disposed of 100 hearing matters, I have directed you include 100. Again 100. In this way, I am trying to dispose of. Okay, mere inclusion. You wait for some time.
My lordship, for the inclusion, my lord. My lord, the writ petition, my lord, is not maintainable, my lord, under any law. As my lord, the loan account has already been closed down, and my lord, the settlement has been reached between the parties, my lord. So, my lord, the writ petition is liable to be dismissed as infructuous, my lord.
Infructuous. Who is the other side?
Uh,
Under the heading to be mentioned, the matter can be disposed of.
yes, my lord.
Huh?
Yes, my lord.
To be mentioned. Have you given to know your notice?
Yes, my lord.
You intimate your other side that the matter shall be
My lord,
appear
I
under
have
the heading
intimated, my lord.
to be mentioned. Shall appear, yes.
Item number 679 minus monthly list for upgradation matter, the hearing matter and the private respondent, the writ petition has filed a writ petition.
You are not the petitioner.
No, I have given notice, my lord. I am suffering. I am the assistant headmaster in the school, my lord, where my post is not being becoming permanent because of the pendency of this writ petition, my lord.
So you could have filed an application. It is not your matter. It is not your matter.
But I am suffering, my lord.
Yes, everyone is suffering.
My
But
lord, everything all
you wait. You mentioned it in the month of September, then nothing will happen. I am to go to circuit. I shall sit since 25th August. So only there shall be 5 days. Okay, and you mention it in September. September, I shall type to you. Upgraded motion. Motion upgraded, there is no hearing, most probably. It is motion. You give the slip.
May I have lordship, item number 573 for upgradation. Already it was in the upgraded list, lordship. The urgency now, after coming the monthly list, lordship, it was included in the returnable hearing, lordship. Urgency is, lordship, the APAR, the annual performance appraisal report of the petitioner that was crossed by the reviewing authority that without any knowledge of the petitioner. Never it was intimated, lordship. That was done in 2015 and that comes to the knowledge to the petitioner in 2020, lordship. Thereafter, petitioner made the representation and on the basis of the said bad APL, lordship, the promotion is denied, the juniors were given promotion. And he's...
It would be retrospectively given.
Lordship?
It would be retrospectively given effect.
Lordship, that the promotion,
If you are
this is the urgency is suffering, lordship. 2021 matter, lordship, 2021 writ petition.
I know for the last
upgraded,
4 years,
lordship.
you
Hard
have
before
not
your
done
lordship.
anything.
Food Corporation of India in the other side.
Yeah,
573, item number upgradation.
pension matter, hearing.
Upgraded matter.
Pension matter,
Upgraded hearing.
upgraded. Pension, yes. Huh?
Hearing matter. My lord, we kind of take it as any.
What is the urgency?
But I notice to the others. The notice is appended here.
Mayor, yes, serving notice to other side will not make a matter urgent. What is the urgency? You are seeking upgradation or preference over the other matters because there are some urgency. There are many matters. Court is expected to take all the matters serially, but you are asking the court to take your matter out of turn, giving preference over the other matters. So there must be some urgency. Okay, you take instruction and then mention. It would be given. You follow the list on Monday and Tuesday, upgraded matter will be given. Wherever it is, it would be given. On that date, none appears, upgraded matter. And those who didn't appear, those who didn't appear, their matter has been directed to be placed at the bottom of the list, so that everyone can get the chance. Okay, upgraded matter will be again on Monday and Tuesday. Item number 4. 8. Okay, listed matter you mentioned when the matter will be called you. Okay. Yes. Yeah. Yes. Oh, pension matter you give this. Pension. Next Monday I am to go to circuit. Tomorrow, okay, if you can ensure his presence. Tomorrow under the heading pension. Under the heading pension matter, আপনি ওদের কথা পরে শুনবেন, আগে কোর্টের কথা শুনবেন। এইটা শুনুন, এদিকে আসুন, এটা পেনশন ম্যাটার কালকে দিই।
The founder members' signature has been fraudulently obtained and resigned, came from the society, and now the entire school authorities accounts being controlled by that fraud person, and the students are not able to exam, not able to sit for the exam, not able to sit for the classes. But that's how I have already mentioned it.
When their examination will be held.
Twice they could not sit for the exam.
Okay, এটা ওই 25-26 তারিখে দিয়ে দেবেন। 25-26 তারিখ। You have given notice to other side? Yes, এটা 25-26 দিয়ে দেবেন। Hearing ওই special issue. Correction under the heading to be mentioned. It to be mentioned. Correction to be mentioned. Yes.
Restoration to be mentioned.
Restoration application given.
Your Lordships, kindly may I be permitted to mention item number 775, Your Lordship. Your Lordship, this petitioner before Your Lordship is a branch manager of SBI, my lord. Allegations against him under the POSH Act, my lord. My lord, the internal committee, my lord, without giving me an opportunity to cross-examine the complainant, my lord, had come to the conclusion that yes, I have done something wrong under the POSH Act, my lord. And my lord, because of this, my lord, my promotion is withheld, my lord. Kindly, my lord, kindly take.
Promotion can be given retrospectively.
Yes, my lord.
Promotion this can be given retrospectively. You consider in this month, this court will today and tomorrow, and thereafter last week of this month, that means 5 days.
I just
you consider only 5 days, 6 days.
Lord,
Today I have urgent side matter. Tomorrow I have a division bench. You consider. You mention this matter that would be effective in the month of September.
My lord, I'll come back then, my lord, with
yes,
the
yes.
My lord, may I be permitted to mention item number 898 for upgradation, lordship. The petitioner's father died in harness during service. After his death, I applied for compassionate appointment, which was rejected, challenging which
898, my lord.
898
Yes, lordship.
compassion updated করে দেবেন
I'm deeply obliged, my lord.
My lord, may I be permitted to petition to hearing matters? They are interconnected.
hearing matter
Yes, my lord.
inclusion
Inclusion, my lord. Kindly.
wait for some time
My lord,
wait for some time it would be included I am not denying you Oliver. Okay, I allow the court to dispose of certain hearing matter. Again, it would be included. Wait, you mentioned in the month of September, your matter will be. 8 year benefit. 20 years benefit, yes. I know. It would be given retrospectively. Retrospectively, don't worry. It can be given retrospectively. Yes. It has been assigned. Assigned matter is taken on Friday. So you keep watch on the list. It is assigned. It has been categorized and it has been included under the heading assigned matter. On Friday, it would be listed. আচ্ছা আপনি দেখে নেবেন তো যে অ্যাসাইন মেথডটা আছে restoration application give under the heading application Okay, mentioned in the month of September, that would be no. I know urgent. I know urgent. I am not denying that you have no urgency. Mention in the September, okay. Let me come from circuit, then mention. No, it would be included. September. Motion give the slip. Huh? Hearing matter. Okay. It would be wait for some time. It will appear. No, from combined list to it will be being on daily list. Don't worry. Daily list. Returnable matter will be taken up on Wednesday and Thursday. Oh, today I am to go to circuit and hence some motion matter and other pension matter I shall dispose of today. Motion, yes.
Your Lordship, I'm praying for inclusion. My interim order is going to expire on 29th of August.
29th of August.
Lordship.
29th of August. So it can be listed on 25th.
Your Lordship could kindly include it.
ওইটা দিয়ে দেবেন তো নেক্সট 25, 26 যে কোনো একদিন দিয়ে দেবেন 25, 26 under the heading extension of interim order living.
CL number 599. I am paying for upgradation, my lord.
What is the address?
I am Group 6 service, madam. Group 6 service, madam.
Okay. Wait, it should be upgraded. Don't now.
Petitioner not getting her salary, my lord.
Disciplinary proceedings. So unless those orders are set aside, how you can get salary? Disciplinary proceedings. You have been dismissed from service, and hence your salary has been stopped. So it is disciplinary proceedings matter, hearing matter. So wait for some time. It will be. Wait for some time. It would be included. Wait for some time. Wait for some time, it would be included, yes. Wait for some time, yes. Wait for some time, wait. Take the urgency. You also upgraded the matter. Whether on that date upgraded matter was called, are you present? I don't know. You have not given notice also. You give notice and then mention. I think on that date, upgraded matter was taken up. Many learned advocates did not appear. Inclusion, wait for some time. Yes.
This matter, when you start this matter under the heading upgraded matter, is related to a higher pay scheme. I am governed by the honorable member of the special bench judge. But since state was not there, your lordship was pleased to adjourn the matter. The matter was gone down.
It was upgraded.
So I appeared since state was not appeared. Your lordship
It is appearing under the heading upgraded matter in monthly list.
specially fixed matter.
Specially fixed matter. I heard the matter.
You also heard the matter. The state was not appeared on that.
While I'm praying for upgradation of a matter, my lord, in my lord's monthly list, item number 882, my lord, I have been denied a subsidy of about 1 crore after installing a machinery under the scheme floated by Union of India upon the ground of paucity of funds. Now, the respondent authorities have floated the scheme once again and also keeps denying my subsidy.
Okay. Mention in September.
Lordship. My lord, I have some notice, my lord, for upgradation, my lord.
No, not now.
In this matter, Lordship, matter has already been listed in upgrade matter, Lordship. Monthly list in the item number 237.
If it is appearing under the heading monthly list, you keep watch on the list on Monday and Tuesday. It would be brought on the daily list. Don't worry. If your matter is appearing under the heading upgraded
matter in the monthly list of 237, Lord. Your Lordship
called 237. That means it has been called.
Lordship, your Lordship called this matter.
Yes. So you have been called. You didn't appear. The matter has been directed to be placed at the bottom of the list. Don't mention.
Lordship, when Lordship?
It will be placed bottom of the list. You will get your chance later on.
I had mentioned this matter on Monday. My Lord allowed my prayer for upgradation of a matter which was pending in the Supreme Court for maintainability, but this has not appeared in the supplementary list.
It will appear on Monday and Tuesday.
Monday, my Lord, will not
upgraded matter.
To the other side, I am mentioning one group 2 matter, but this matter is related to the admission of a student in the computer science and engineering in Jadavpur University.
It is in the list, or
it's not in the list. It has to be listed because the matter was heard extensively by the Honorable Justice Joy Sengupta, but due to change of determination, it could not. The report of the Jadavpur University is on record and exception has already been taken. But it will be very short, my lord. Let it appear.
I heard this matter.
No, my lord has not heard. Upon notice, I am mentioning, my lord.
That ragging matter, Jadavpur, that matter.
No, not ragging. Admission of a student under the EWS reservation scheme.
The session has commenced. So how you for the next academic year?
Whether university has already.
Whether in this academic year you have.
No, my lord, in the matter, we will satisfy that in the meantime, the university has already admitted students under the said quota.
The academic session is already commenced.
Let it appear.
Whether it would be possible to accommodate in this academic session.
Well, there are 10% of reservation under this policy. But this is approved by the government of India and approved by the.
Okay, yeah.
My lord,
You
one-
mentioned the one matter.
Another lordship, one upgraded, already in the upgradation list as item number 282 lordship. Since it is lordship, higher scale of pay, similar to Utpal Kanti Karan lordship. My humble prayer lordship, 243 it was called on lordship. Upgraded matter was called on up to
So it would be,
282 lordship. Let it appear at the heading to be mentioned so that matter could be heard after your returning.
no, no, it would be, wait for some time.
I'm mentioning for inclusion for hearing, my lord.
Wait for some time, Mary. Yes, call the list.
Item number 1,
দেখুন ম্যাটার দিন তো ম্যাটার ইনক্লুড করেও এগুলো করতে হবে 8 জন নয় তো ডিডি dismiss for default.
item number 2,
My lord, I am in behalf of petitioner. We want to withdraw the case. I have been instructed to.
Have you got the written instruction?
My lord, the written instruction has not been.
It is for your safety.
My lord, we will file.
What is your name?
Mr. Dibyendu Ghosh only.
Have you signed the Vokalatnama?
No, my senior signed the Vokalatnama and I am.
So not today. You come with written instruction or you show your name from the Vokalatnama.
Yes, my lord.
Otherwise, maybe anything happen.
My lord, contention.
Other side can come and say, I do not want to proceed.
Yes, my lord.
Okay. Always when your client will instruct you to withdraw or to get the matter dismissed for non-prosecution, you will at least call for the instruction, written instruction. It is for your safety. At least you send a mail or anything.
My lord.
Okay, and get it on record.
My lord.
Not today.
number 3,
তুই দেখি কি আছে ওয়ান 144 হয়ে গেল করতে ডিডি
item number 4,
ডক্টর হিয়ারিং করবেন সিনিয়র সিটিজেনের একটা 15 লক্ষ টাকা নট টুডে একজন মোশনে এগুলো দিয়ে দেবেন বুঝতে পেরেছেন হয়তো হয়ে গেছে হ্যাঁ যেগুলো নট টুডে হচ্ছে
item number 5,
Lords, in item number 5, I'm appearing for the petitioner. The writ petition as on date stands infructuous, my lord. My lord, by past necessary.
Have you got the written instruction?
No, my lord, because I have the client's instruction, not right now in court, my lord, but I am well instructed that the relief sought in here in this writ petition have been infructuous. The reliefs sought have been adjudicated upon, my lord.
Oh. So your name, please?
My lord, Sakshi Tiwari.
Acha, Ms. Sachansha Lanet, advocate, appearing on behalf of the petitioner, submit that with the passage of time, the petition has become infructuous.
item number 6,
দেখি ও বলে দিচ্ছি যাচ্ছে। Did.
Item number 7.
Did.
Item number 8.
Lordship, may I permitted to mention? Lordship, kindly release this matter. This is a matter under Group 4, and it's come in.
So the matter
filed on this court.
Matter stand released due to want of my determination.
Grateful, Lordship.
Can release from my list.
Item number 9.
No.
Is for default.
Not today. Yes.
Matter item number 11.
Yes, ma'am. My lord, I am for the petitioner. But this is in the motion stage. But it was. But what happened? The petitioner is in the business of transporting cylinders. He has a transport business of transportation of cylinders of HPCL to different places. Now, he purchased certain trucks for making body, and the accused is also was in the same business. So the accused, the civil of the accused was not proper. He was not getting loan. He requested me to help him with the loan which I had. I helped him with a loan of rupees 1 crore 9 lakhs. What happened? He told me that you help me with the loan, I will help you raising the bodies on the chassis.
How you help him to get a loan?
He has, there's a good, he has a garage at Kamlu. He will help him raise the bodies. No matter I gave him the body at trucks, he was neither returning the money nor returning the trucks. Then I filed one case, Tumluk PS case number 335 on 30th March 2023 against him. As a counterblast, he filed 387 on 12th April against me. Now his case got resulted in a final report. I got a charge sheet against him. In the meantime, he had come to the High Court for expeditious disposal of the case, and the High Court also directed the magistrate to decide whose trucks those were. The learned magistrate
Directed the magistrate who?
whose trucks were those trucks were. I got the trucks from the court of the magistrate as per direction of the Honorable High Court, and the learned magistrate gave me the trucks. Now, after his case got final report, what he did, he filed a Naraji petition.
Yeah.
But instead of pursuing the Naraji petition, he filed another case against me that was at Bhawanipur PS. But if your lordship comes to just a minute, my lord.
You are appealing for
I'm for the state, my lord.
state, and you?
He is.
No, my lord, in the meantime,
kindly have a look, my lord, the report filed by the investigating officer. My lord, page 23 to
this is
supplementary affidavit, 23 to 25, my lord.
It was called for, the report was called for by the court.
No, my lord, what happened, my lord? No, my lord, what happened, my lord? He filed, instead of pursuing the Naraji, he filed another case against me at Bhawanipur. I got a stay in that case. And then
Stay from
the Honorable High Court.
In another revision.
Same FIR he filed from another PS. Then third time he filed this FIR. Same FIR he filed this. Now, when in this case I got anticipatory bail, the police, when I filed this case, the IO got my accounts freezed, debit freezed. He got my accounts debit freezed.
In third case?
In the third case. In the third case. And I filed a CRAN before this Honorable Court because the quashing petition was pending. But the matter could not be heard of. In the meantime, the petitioner filed a prayer for return before the learned magistrate. There, the IO said that he has no objection if the accounts are defreezed. That is what he is showing. No, but my accounts are freezed. Let those and then the report came that he has no objection. But since this CRAN was pending in the High Court, we had to not press the application for defreezing of the account. Now, my lord will pass the orders for defreezing the account and pass a stay order in this.
In supplementary affidavit, my lord, kindly have a look. 24, page 24 and 25.
So in absence of the de facto complainant,
his presence is not required at this stage. But moreover, the IO has given the no objection. He was present at that time also. But it passes an interim order of defreezing. And in the meantime, I'll serve him if he files, if he feels he will pray for recalling. Madam, sees the supplementary affidavit.
Have you annexed the 3 FIR?
Yes, yes. All 3 FIRs are annexed.
Okay, you show the first FIR.
Madam, first FIR is
lodged against you.
Yes, Madam, first FIR lodged against is at page 1112.
Page 1112.
This resulted in final report, my lord.
Page 1112 is a order sheet.
This is, madam, this is the order sheet, GR 1162, PS case number 387, dated 12th April.
Court wants to see the FIR. This FIR number is Tomluk. First FIR against the petitioner is
387.
Tomluk PS case number 387 of 2023. Dated 12/4/2023.
This resulted in final report.
Under section 406, 420, 468 and 506 IPC.
And 34.
Now,
and also 34.
okay, 34 means more than you and your associates.
Madam.
Alleged associate.
Madam.
Don't take it otherwise. Okay. So this FIR, in this FIR, the complaint was lodged alleging an incident occurred on which date?
Madam, this was, madam, if you also see the entire charge sheet here.
Charge sheet, okay.
Charge sheet is, the final report is
This
also
case, final report, file number 5723. This is
523.
This is 23 was filed.
Dated 20.
He filed 173 clause 8 petition.
Madam.
Okay.
Now,
part did not pursue.
Yes.
So ultimately it was dismissed.
No, it continued.
Still pending.
Pending.
Acha, still pending for final adjudication. Still pending for final adjudication. Okay. Now, secondly, he has filed Bhavanipur
PS case number.
Bhavanipur PS case number. Case number?
Madam, that was just a minute, madam. Madam, page 121.
121. Yes. It is Bhavanipur.
Bhavanipur, my lord. This is Bhavanipur 1050. No, my lord, sorry, this is not that. I'm just showing. This is the cases, other cases pending against him.
94. It is Tomluk PS case number.
That is not that.
It is Tomluk
No,
PS.
madam, just a minute, madam, I'm missing something.
It is Tomluk PS case number 1050.
94 of 2020.
Oh.
90, yes. 94. He filed 94.
94 is some balance sheet.
No, my lord. 94.
Mr. Singh.
এটা কোথায় তো ইয়ে সুব্রার অর্ডারটা
এখানে আছে।
হ্যাঁ বলো তো কোন পাতায়?
Annexure C, page 2324.
Page
2324 ইয়েতে ওই আপনার না সাপ্লিমেন্টারি এটা না এই যেটা।
Your name is Prajesh Chatterjee.
Prajesh Chatterjee.
Prajesh Chatterjee. And your de facto complainant name is Samkulia, Sondip Kulia. Sondip Kulia, yes. From Sondip Kulia. Achha. I would like to ask you, it is Tomluk PS case number 10. So Tomluk PS case number 10331.
No, my lord, the second case, my lord, which he filed was at Bhavanipur.
Yes.
I filed a
Bhavanipur case number
94.
94 of the কথা?
2024. 24 না
94 dated 9th April 2023 24.
Yes.
Now, my lord, I challenge that order if your lordship comes to the CRAN 1.
Which order?
If your lordship comes to the CRAN 1 of I have filed a CRAN 1 also, my lord.
Yes, can one.
CRAN 1
NXSC
Annexure C. Page 23.
Annexure
C. At page 23.
last 2 pages
Last page.
Yes. Yes.
Here, Justice Subra goes, kindly goes through the order. This is the second case. No positive order was passed here.
Again, case, but
last 2 lines
in the cost title, you says that
My lord, I have got the other copy.
it is the third case, Mr.
This is the second case. The present one is the third case. Third case is at page
Tomluk PS case number 1031 of 2024 is the third case.
Yes, my lord. This is the third case.
Yes.
This is the third case on the same facts.
Tomluk PS case number
1031.
1031 of 2024.
Yes, it is dated 22/11/2024.
Yes.
All on the same facts.
And hence I want.
No, my lord, now in this case, I got anticipatory bail. After I filed this case, the revisional application, he freezed my account. Since he has freezed my debit accounts, what I did, I filed a CRAN saying that because the matter was pending here, I prayed that the accounts be decreased. Now, in the meantime, I also filed an anticipatory bail application which was allowed by the Honorable Court. My lord, this is the anticipatory bail order.
Oh, Mr. Singh,
My lord,
what you are saying, it is called doctrine of sameness.
yes. Doctrine of sameness.
Doctrine of sameness.
Sameness.
That means regarding one incident, there must be one complaint.
Yes, my lord.
Yes.
Anthony's case.
So the incident is same,
Same.
date almost date same. So you show 3 FIR
Yes, ma'am.
only to satisfy that there is a sameness in 3 complaint, 3 different complaints. And if you can show that, you will get the and lastly you will show the report of the IO. You could have brought 3 FIR.
I don't have the second FIR just now. Can you see this?
Okay, you first FIR and third FIR.
Can you see this order, my lord? What the bench had observed.
Yes.
But can you see this order?
It is.
But kindly comes to.
Yes.
The petitioners got, my lord, as a counter plus so and so. Then second place, a final report was filed in this case. The present de facto complaint filed in RRD, which is pending consideration. Despite this, the petitioner filed a second case over the same facts on 9/4 April at Bhawanipur PL. The petitioners preferred an application for quashing. A coordinate bench of this court on 27/1 granted relief to of no coercive action against the petitioners in so and so. The revision is pending. In spite of all these, de facto complainant started a third case on the same facts. The only addition being the petitioners were already using his past acts. The learned counsel appearing on behalf of the de facto complainant opposes the prayer for anticipatory bail and submits that there are clear differences in 3 complaints. Learned counsel appearing on behalf of the state relies on the case diary and submits that the de facto complainant has in fact filed 3 cases against the petitioner substantially on the similar facts. The addition in the third case is that the petitioner alleged used fast track code tags. Now, my only prayer in this case
is to decrease my account because I am suffering of last 2.5 months because of my account.
Okay, now
He has to-
you show the report.
Kindly have a look, my lord, the supplementary,
Report.
supplementary
Supplementary
affidavit, page 23 to 25, relevant portion 24 and 20.
Mr. Singh, you could have produced এই সাপ্লিমেন্টারি বিলটা কোথায় দেখুন তো সাপ্লিমেন্টারি you could have brought the 3 FIR and the report. It is application modification. It is an application can additional relief.
My lord, that one, my lord, an application for modification of the prayer due to subsequent development. That petition.
Oh.
Yes,
you go the report.
Page 23.
Page 23 report.
Start from page 23, my lord, relevant portion.
Relevant portion, yes.
Relevant portion, page 24, last 2 paragraphs.
Last 2
25,
paragraphs, yes.
Page 25. This, my lord, will help, my lord, to pass necessary order by your lordship. আপনি বললেন।
অ্যান্টনি তো দ্রুত মামলা আর হবেই না। আমি এটা হয়ে গেলে সব মামলা একসাথে
চলছে
একটা কোটি
আমি ওই দেরি হচ্ছে বলে দৌড়ে এলাম, না আমি আসতে পারতাম।
Now, what pair have you made?
Defreeze the account.
Defreeze that account.
Defreeze the 7 account. Same.
7, there are 60 where other all the accounts in name of the
5, 6, 7, 8, 9, 10. 10 accounts.
Yes, madam.
But your pair is defreezing of 7 accounts.
No, madam, it is actually 10. But that time, madam, the day I filed it, he defreezed the other 3 accounts again. Thereafter.
Okay. So freeze in connection with this case.
Correct.
Freeze in connection with this case, that would be sufficient. Okay.
That is in respect of Tomluk PS 1.
Jan 1 of 2025. This application has been prepared, praying for an appropriate order in view of the sudden subsequent development during pendency of the revisional application being CRR number 598 of 2025. Where is the Justice Ghosh Subra Ghosh order?
That is at page, madam, also.
Additional relief, that application, additional relief due to subsequent development, page 23 and 24.
Page
23
and
24,
23.
Annexure C.
Annexure.
Got it. The following some commercial transaction in between the petitioners and the de facto complainant, one dispute cropped up. Stop. That dispute led to initiation of 4 criminal cases. One has been
387, 94 and 1031. And 1 DLP file.
4 criminal cases. Stop. three of which were lodged against the peasant petitioners, and one was lodged by the petitioners against the de facto complainant. Stop. Mr. Singh, learned advocate, representing the petitioner, submits that initially the de facto complainant filed lodged a complaint before the Tamluk PS case, Tamluk police station on 12th April 2023.
He's senior advocate.
No, no,
Sorry. No, sorry. Thanks for giving that. As a senior advocate, ঠিক আছে? Based on this complaint, the Tamluk PS case number 387 of 2023 dated 12th April 2023 under section 406/420/506/34 IPC came to be registered against the peasant petitioner. Stop. After investigation, the final report filed FRMF number 575 of 2023 dated 13th July 2023 was filed. Stop. The de facto complainant, as aggrieved thereby, the de facto complainant filed a petition under section 173 within bracket 8 of the Code of Criminal Procedure, 1973, which is commonly known as Naraji petition. This petition is still pending for final adjudication. Stop. Subsequently, regarding the same based on the same allegation, same facts, the de facto complainant lodged another complaint before Bhabanipur PS, which gave rise to registration of, which led to registration of Bhabanipur PS case number 94, dated 9/4/2024, 9th April 2024. Stop. Petitioner filed a revisional application being CRR 4847 of 2024 before this honorable court with a prayer for quashing of this case. Stop. A coordinate bench of this court, by passing an interim order, directed that the investigation of this case will proceed. However, no coercive action shall be taken against the petitioner. Until 31st March 2025 or until further order. Stop. Mr. Singh submits that this interim order was extended time to time, and the same is still in force. Stop. Subsequently, the de facto complainant filed another complaint before with Tamluk PS, based on which another case by Tamluk PS case number 1031 of 224 dated 22nd November 2024 was started. Mr. Singh invites my attention to an order passed. Mr. Singh, Mr. Singh submit that the petitioner filed an application praying for their PRS bill, which was registered, and that application was registered as CRM within bracket A 1251 of 2025. Stop. He submits that, taking note of the fact that the de facto complainant filed 3 cases against the petitioner substantially on similar facts, the benefit of PRS bill was extended in favor of the petitioner.
Sir,
benefit of extended. He submits, therefore, it has been.
Sir, I am the de facto complainant. May I be allowed to make my submission?
That the de facto complainant lodged 3 cases.
Sir, I am the de facto complainant. May I be allowed to make my submission?
He submits that in connection with the in Tomluk subdivision.
Yes, yes, ma'am.
In Tomluk.
Not Tamluk, my it is in Durgapur.
Across the state,
Sir, I am the de facto complainant. May I
have been fixed. Across the state?
Yeah,
across the states have been fixed. He submits that due to such action on the action of freezing the account, they were following such, but due to, and since those accounts have been freezed, the petitioner's business has been seriously hampered. He submits that a direction should be given upon the concerned bank or investigating officer to take necessary steps so that those accounts are freezed. So, he also submits that.
Hello, sir, may I be allowed to make my submission? I am the de facto complainant in person.
He draws my attention to the report submitted by the investigating officer before the Court of Learned Chief Judicial Magistrate Tomluk, where the investigating officer has categorically stated that those accounts were not directly involved in this case. Stop.
As such, my lord, at this portion,
my lord, may I be allowed to make my submission? I am the de facto complainant in person.
You are Mr. Bordhon.
Yes,
Mr. Bordhon, learned advocate representing the
Rajesh Jana.
Mr. Bordhon, learned advocate, duly assisted by
Mr. Rajesh Jana.
Mr. Rajesh Rai, appearing for the state,
Jana,
appearing for the state, concurs with the submissions made by Mr. Singh on behalf of the petitioners that the IO after inquiry, the IO, upon inquiry, upon inquiry, the IO found that the accounts which were previously freezed were not involved in the case registered as Tomluk PS case number 1031 of 2020. Stop. Heard the learned advocate appearing from the appearing for the respective parties and peruse the materials of the court. Stop.
Sir, may I be allowed to make my submission? I am the DC
Admittedly,
person.
a coordinate bench of this court, in its order dated 29th April 2024, passed in CRM within bracket A of 1251 of 2024, observed that the de facto complainant has in fact filed 3 cases against the petitioner substantially on similar facts. ঠিক আছে?
Sir, may I be allowed to make my submission? I am the DC in person.
Right. Therefore, it prima facie appears that doctrine of sameness may apply to the present case being Tomluk PS case number 1031 of 2024. In connection with those accounts, in connection with certain accounts of sameness ইয়ে আচ্ছা কি বললাম এখানটা আচ্ছা and acha needless to state that if it is ultimately concluded that in this case that following the doctrine of sameness, the subsequent case cannot be allowed to be continued. Doctrine of same ওইটাই করুন নাহলে এটা ইয়ে হয়ে যাবে therefore taking note of this fact of the taking note of the
Sir,
fact
may I be allowed to make my submission? I am the de facto complainant in person.
The considering the possibility of application of
Sir, I am the de facto complainant in person. May I be allowed to make my submission? Sir, I am the de facto complainant in person. May I be allowed to make my submission? Sir, may I be allowed to make my submission? I am the de facto complainant in person.
and without any
My submission.
Acha. Stop. Here direction was given to serve upon the de facto complainant.
No, it has to be given.
Yes, I am served.
The
And I am to
application
make
is
my
thus
submission.
disposed of. Stop. Acha. The IO is directed to act on the basis of the server copy of this order without insisting on production of certified copy of this order by the petitioners. Stop. এবার CRR আপনি CRR number 598 of 2025. আচ্ছা. Who is this person?
Sir, I am the de facto complainant in person.
I can't, he is not audible.
Sir, I am the de facto complainant in person.
You unmute your,
Sir, I am the de facto complainant in person.
your name is appearing as Suman Roy.
No, my name is Sandeep Kuila. Somebody wrongly inserted. I had categorically stated my name is Sandeep Kuila and I mentioned my name in the chat room.
Oh. Yes, I am directing
The issue you have my article 21 is seriously affected due to this non-submission. The entire episode that the landed senior advocate had presented, he is misleading the case. Actually, the first case that was registered, I am totally cheated by his client. Subsequently, the FIR which was lodged, that was permitted as per the judgment of the Supreme Court of India in the various judgments. Subsequent cause of action arose. That is why subsequent FIR was lodged. And pertinent to mention here that the learned Chief Judicial Magistrate Tomluk had rejected.
Okay, here, Mr. Kulia. Now, at this stage, court thinks that hearing, opportunity of hearing is to be afforded to you also before taking final decision in this matter.
Yes, sir.
The final decision is not being taken now.
Sir, okay. I want to make my submission.
Your grievances will be effectively addressed. Don't worry. I am directing the petitioner to serve a copy of this application, revisional application to you. You read it minutely, and thereafter get yourself prepared and come and make submission. Whatever you will submit, that will be dealt with properly. Don't worry.
Highly obliged, sir. In that case, if any ad interim order was passed,
passing an interlocutory order or interim order in a matter does not mean that entire matter has been disposed of and the proceedings have been terminated.
The issue is that
nothing to be worried about. If you have a justified claim that
sir, I have a justified claim.
Grievances
Please call for the CD. Sir, my humble submission is that humble submission is that Honorable Chief Judicial Magistrate.
Mr. Kulia, court is such a place where argument is made by the learned person.
Yes, I am the de facto complainant in person.
It is an argument and it is mere submission, not quarreling or altercation. Okay, and there is some
staging. The issue is that why this ad interim order should not be passed. I am telling you that. Sir, at 482 of the CRPC, there is no scope of trial. The learned Chief Judicial Magistrate already rejected thrice. They are
you in legal profession?
Sir, I am not in legal profession. I am in person.
Okay, so get yourself prepared and
sir, I am ready to make my submission also today. I am also ready to make my submission today.
Not it is the stage now. Not it is the stage now. Okay, I am asking them to serve the copy of the application. You apply your mind. Don't be swayed by your emotion.
Sir, I am not with my emotion. I am with certain specific documents. Each and every document is there. The client, the accused person has cheated me more than 20 crore rupees.
Mr. Kulia, one coordinate bench, this court has noticed, one coordinate bench expressed annoyance.
Sir, issue is that,
Mr. Kulia, one coordinate bench expressed annoyance.
Sir,
and
not
release the matter.
Sir.
Release the matter. I have read I have read the word used by the coordinate bench.
Sir,
and
I am telling
at that time you interfere. Look,
sir, I was waiting at the chat room for a long
the
time.
Court has not called you as yet. Court has not called you as yet. Court is directing you to serve a copy of this revisional application and fixing a date. On that date, if you are think yourself to be capable of making argument before the Honorable High Court, then you make application. or otherwise you can take assistance of the learned lawyer from the panel.
Sir,
And
I am capable
you
of
can-
submitting. I am capable of submitting my submissions.
Okay, okay.
Please fix
আচ্ছা।
a date.
আচ্ছা, after having আপনি কোন সিআরটা করেছেন তো? সিআর এর নাম ছিল having heard the learned having heard the learned advocate appearing for the petitioner and state, and upon perusal of the materials on record, I am of the view that issue raised in the present revisional application need to be addressed, and the same is needs to be addressed and resolved after affording an opportunity of hearing to the de facto complainant. In view thereof, the petitioner are directed to serve a copy of this application along with all annexures thereto. There is any pending application?
If this application has to be disposed of, I will send this as a supplementary. Or I can send it.
Yes, a copy of this revisional application and any connected application, if any, to the de facto complainant, and file affidavit of service on the returnability. Stop. Now you say,
I mean, it is a short stay.
Huh?
Short stay. Short stay of the investigation proceedings. But doctrine of sameness, your lordship has already observed.
Already of the prima facie,
Prima facie.
as it has been held that the facts and circumstances suggest that in the given case, prima facie suggests that in the given case, the doctrine of sameness may apply. Sameness apply. I intend to pass an interim order that investigation of this case, investigation and the probe of this case will go on. However, no coercive steps shall be taken against the petitioner until the end of September or until further order, whichever is earlier. Now, you say which date would be convenient to you in September?
Sir, whichever you sir prefer.
You say which date?
3rd week of September.
Huh?
3rd week of September.
Sir,
No,
if
no.
it is,
Not
sir,
hard.
if it is in August, I am also okay.
August, I have a circuit. I am to go only.
No issue, no issue, sir.
Okay.
No issue, any date at September. No
I
date in
shall
September.
sit from 25th. And this week, your learned friend, all the learned friend has booked. Last week of October, all booked. I have already fixed many matter. Okay. September, দেখুন তো তাড়াতাড়ি একটা ডেট দেখে।
Second week of September.
Second week of September, ওখানেও খালি সব। কবে কোন দিন ফাঁকা আছে, কম মামলা আছে? পরে কি আছে? তারপরে দিন আমাকে September. 4th September, would it be 4th September? 4th September, it is under the heading specially fixed matter. For as fixed matter, under the heading fixed matter. 4th September.
Highly appreciated.
Okay. But you keep it in mind that the court is such a place, I am reporting, excuse my repetition, court is such a place where submission or argument, whatever, advanced by learned person.
Sir, I am capable of making my submission.
At the time of submission, their behavior and use of word would be such so that it may appear that they are really learned person.
I am capable of making my submission.
Yes. Next. Sameness, any double S.
don't resort to taking the APC as declared red listed.
Okay, here issue I have indicated that would be the issue. That would be the issue. Huh? That would be the issue. You, rather it would be convenient for both of you, you bring 3 FIRs.
Sure, sir.
Otherwise, court will be forced to find it from another brief. You ask your junior to keep it 3 FIR. Compilation, if you can also you can prepare. Next.
Your Lordship, item number 12, I beg to appear on the stage of state. I beg to appear for the petitioner in this matter, Your Lordship. And Lordship, in this case, the respondent number 2 to 4 have filed their objection on the last occasion. We have to file the reply. Well, Your Lordship, the reply is ready, but the client is not available. That's why I need a 1 week's time to file my reply. Otherwise, it's ready for hearing. We have filed the reply.
On that date also, you press for extension of
On that date only, they filed the objection to us. They have served the objection. That's why we couldn't prepare. Your Lordship.
my Lordship. Mr. Ganguly.
Yes.
Mr. Ganguly, learned advocate representing the petitioner, press for extension of time to file affidavit in reply to the
In 13 Lordship, I beg to appear on behalf of the petitioner. Lordship, kindly recall, this is a matter on the last occasion Mr. Mujumdar argued in this matter. It's relating to the finance officer of Bardhaman University. Previously, my lord, he was, my lord, in employment with the central government, my lord, the AG. Lordship was kind enough to direct, my lord, the AG authority, my lord, to file one affidavit, my lord, stating the whole facts, how much he received at the time of leaving his job from AG and then joined with the Bardhaman University. Lord, we have
copy has been served.
Yes, my lord. We have no objection.
We are the main contesting party. We are the university.
University
2 and 3.
I am giving it. No dispute.
The report in the form of affidavit filed on behalf of the respondent number 4 in terms of the order dated 15th July 2025 has been filed. Have you exchanged the affidavit?
I've already, I'm for the state, my lord. I've already submitted the affidavit in opposition the last occasion.
The parties were given liberty, yes. The affidavit in reply filed on behalf of the petitioner is taken on record. You are the only answering respondent.
I'm the state, my lord.
State is the only answer.
I'm just taking it. The state is the main
Affidavit in
respondent.
reply filed on behalf of the petitioner is taken on record.
No dates have been mentioned. Only kindly take the affidavit in opposition. I will come to the writ petition for thereafter, my lord. Kindly take the affidavit in opposition.
No order has been passed. Why they arrived at a conclusion that
They said that there are initially
secretary passed an order?
that they have
Secretary passed an
already.
order.
Kindly see the interim order once, my lord, the passed by the Honorable Justice.
Affidavit in opposition, secretary passed an order. So secretary, yes. Additional
That 809 days, my lord, the 809 days is on the non-medical ground.
It's on medical.
Extraordinary.
Arey baba, darao na bhai, তুমি
Again, that
jump করো না।
one report is there.
Yes.
And the affidavit in opposition.
Yes, I am on affidavit in opposition.
Yes, my lord, just I'm showing that how they have deducted, my lord, the amount.
Pension payment order.
No, nothing is disclosed in the pension payment order.
Well,
The judgment is good. Here is that vote.
allow him. It is his case. Allow him to place his case.
My lord, kindly take paragraph 7, my lord, page 6.
Yes.
That in the order dated 24th of September 2024, that is the order passed by this honorable court. The respondent authority are directed to release the admissible due to the petitioner, including pension, by 4 weeks from the date of communication. It is submitted that the pension payment order of the petitioners has been issued by the Assistant Director of Pension and Provident Fund Group Insurance as per sanction issued by the District Inspector School, Kolkata. At the time of issuance, the pension payment order 8,39,790 has been shown as withdrawal in the pension payment being the salary of 809 days, which is pending adjudications before the Honorable High Court, Calcutta, on exchange of affidavits.
So you have done excess pay of salary, excess pay of 809 days.
That they had.
It is their
allegation.
Their allegation that you have enjoyed this excess pay beyond your entitlement.
I had served 4 schools. I had served during my tenure 4 schools at different locations in West Bengal.
Yes.
Now, for which schools, how many days leave were calculated, and at what rate? What was my what amount was deducted? What amount was shown to have been overdrawn for that particular school? That no, these breakups are required. In any event, there are 2 things, 2 main argument that they never claimed this because they were unable to claim it because of the earlier division bench order.
Now after retirement, they tried to recover it, which is not permissible. A number
What
of
is Rafiq Basi's judgment and
not only that, even in 2023, it has been reiterated by the Supreme Court. You cannot. Now, before that, kindly take the writ petition once, Malad. And kindly take note of the schools that I have served. Malad, I was initially appointed in Robindro Balika Vidyapith. It's a junior high school.
List of dates says Sekhalipur High School.
No, initially, list of dates.
1992.
Yes. Yes, yes. Sekhalipur is first. Sekhalipur was the first, then Robindro Balika, which was initially junior high, that was upgraded to high schools, and I was appointed as headmistress pursuant to the recommendations of the School Service Commission. Then, there was absence, my salary was not paid during this period. Kindly take page 53 straightway. That is the order covering 809 days. Three.
Yes.
It was passed in an appeal preferred by the district inspector school because he was sent to jail. And that person is now in Kolkata. That is why this all happened. He was sent to jail by the learned single judge on contempt. Now, he preferred an appeal. Even the headmaster of the particular school was also sent to jail. He didn't prefer an appeal, but he avoided his jail term by what means, I don't know. Now, kindly read this order, page 53. The second paragraph. This appeal being MAT number such and such is directed against an order passed by the learned single judge in a contempt proceedings dated 7th April 2000, whereby learned single judge issued rule for non-compliance of the order dated 20th August 1999. The learned single judge, by his order dated 7th April 2000, directed the respondent state that all areas of salary of the writ petitioner from June 1994 to July 1996. If you calculates, it comes to 809 days, nearly 800 days. Be released to the writ petitioner and her service be regularized, sanctioning her leave for her absence from June 1994 to November 1996. Then, the learned single judge also directed that this order should be carried out within 8 weeks from the date thereof. The learned single judge also directed the respondents to regularize by discounting the petitioner's absence from June 94 to November 1996, and all other increments which are due to her may be released to her. Even increments were directed to be released. This order was not complied with. Next page, therefore, the contempt proceedings was initiated and the learned single judge, by the order dated 7th April 2000, directed that the district inspector of schools concerned, who was present in the court, Sri Alok Sarkar, be imprisoned for a period of 6 months. Likewise, headmaster and the secretary of the concerned school and also directed the officer in charge of the High Court Calcutta to arrest them. Being aggrieved against this order, the present appeal has been filed and the operation of the order was stayed by the division bench. The learned counsel for the appellant, Sri Alok Sarkar, submits that all amounts which are due to the writ petitioner have been released to the school authority, school concerned, and 50% of the amount has been received by the writ petitioner. As stated by Mr. Bhattacharya, learned counsel appearing on behalf of the writ petitioner. The learned counsel for the writ petitioner submits that the remaining 50% of amount has not been released to the writ petitioner. So far as Sri Alok Sarkar, the district inspector school is concerned, it is alleged that the whole of the amount of the arrears has already been deposited to the concerned school and state has already discharged its burden. The learned counsel for the appellant Sri Alok Sarkar submits that the appellant Sri Sarkar, district inspector school may be discharged as the order in question has been complied with. Therefore, so far as the appeal filed by the district school Sri Alok Sarkar is concerned, that stands disposed. Therefore, the order passed is set aside qua the appellant. It has been brought to our notice that since no appeal has been filed on behalf of the headmistress and the secretary of the concerned school against the said order, the impugned order will survive as against them. If there is any appeal filed, the headmistress and the secretary of the concerned school, the same will be considered accordingly. Otherwise, the order remains intact against them. The school authority shall release the remaining 50% of the amount deposited by Sri Sarkar and the district inspector school to the writ petitioner forthwith. The service of the writ petitioner should be regularized and the service record should be completed and sent to the district inspector school for his counter signature, and thereafter be sent to the writ petitioner who is said to be working as at present the headmistress of the another school, namely Santoshpur Girls High School. With the aforesaid observation, the appeal being such and such is disposed of. Now, what they did,
that means that period which was regularized, now you are claiming.
You are claiming. Now, why they are claiming in the service?
Lies there.
In the service book, the same headmistress and the same DI, what they said that this 809 days is sanctioned as leave on non-medical ground and without pay. That has been mentioned in the service book, which was first time brought to my notice in 2023. They released the salary, they complied the order, regularized, but the resolutions they adopted, which was recorded in the service book, that these 800
resolution of the managing committee
of the school, they completely went on violating this order. They recorded that this leave is sanctioned without pay.
Where is that? Where is the
yes? I'll show it.
Without pay.
Yes, I'll show. Kindly
all kinds of leave taken by her are sanctioned by the managing committee and her service has been regularized as per the order. Also, her service of the school has been verified as accountant. Service from Ato to Ato.
Kindly take
was continuous and without in break. Where is without pay?
Yes, that is
page
in service book. I'm just coming, my lord. পেজটা বলো 7, 8, 9, 10 11 Just a minute, 60, 63, 63. Yeah,
okay, is it? Are you claiming over here overdrawal for this period?
Kindly think, two things.
My submission is that, my lord, it is a question of availability and opposition was submitted. So related to the 809 days leave only, which is considered as a without non-medical ground. Hence, that amount has been deducted from this. I have the report.
Resolution.
Where is that decision?
This is the report from the school authority, my lord. Again. Objection about. On 5th May 25, it is a report from the school authority.
Who is headmaster or headmistress now? Or secretary of the managing committee?
Headmistress, I think.
Kindly first take page 60. What they initially did, that has been recorded, page 60, in our page 9, right hand side, bottom.
Page?
Page 60.
Yes.
On the right hand side bottom, the survey, the 2nd June 1994 to 30th November 1996 has been regularized and payment of salary have been paid for the above period in terms of the Honorable High Court's order dated 18th April 2000 of MAT such and such, MAT such and such. Now that was recorded initially. Now page 62 kindly come.
Clearly stated. I leave without me.
Now, what they did subsequently, page 62, right side bottom, leave without pay on medical ground. Has you also got it? Now, this resolution is also there. My lord, kindly take page 66.
63.
66.
Oh.
66. That is the leave accounts of that particular school, the Shakhalipur school. Kindly take
leave without pay.
Leave without pay 809 days on medical ground. Now that has been now in the order, it has now claimed it is a non-medical ground. Now, while deducting. In any event, it is them who paid the salary pursuant to the order of the court, but they recorded it without pay. And that is on that basis, they are now claiming that you refund. It is not permissible. They are trying to go behind the order, which has...
what was the dispute?
Dispute is only that
Here is, my lord,
Now,
dispute is
what
only
they
for-
did subsequently,
the
my lord,
dispute is only regarding that 809 days.
not only 809 days, if your lordship goes by
No,
the...
no, my evidence in opposition is related to only that thing, my lord. The 809 days medical, it is on non-medical ground without pay. It is in the evidence in opposition para number D, my lord, wherein that after that the school authority of Shekhalipur High School, District Murshidabad, had provided a copy of resolution dated 22/8/2023, wherein it appears that the petitioner had availed 809 days EOL, extraordinary leave, on non-medical ground. Hence, the said 809 days must be treated as non-qualifying service period.
Now, your lordship has seen what they did. They not only regularized, now they are virtually violating the order of the division bench by saying that it is to be treated as non-qualifying service. Then it reduces my increment, everything. Even the pension calculations come because without total service period has been reduced. They have done dangerously. They are not only recovering, but they have said that it will go outside my service tenure also. It reduces my pension, it reduces the increments, and that is why they have not given the breakup. But if any judgment is required, Rafiq Masi, your lordship is well aware, I'll give the other judgment, that is 2022 SCC Online SC 536 is in Thomas Daniel. Reiterated, same thing. আর কপি আছে তো আপনার কাছে নেই আনেননি টমাস ড্যানিয়েলের জাজমেন্টটা টপিক মাসে দাও
There is a judgment of division bench of this court also, Justice Tandon.
Yes, yes, but I didn't bring it since I have brought the Supreme Court.
So how?
Then it has to be decided whether 8908 is correct or not in the separate proceeding. The question is 809 days. Yeah. Then the school authority is telling that it is non-medical ground.
Their resolutions also doesn't say that non-medical ground.
That
They have
will put
always
right.
said medical ground.
So here they are telling that it is non-medical ground. My lord.
My lord, even kindly take 21st March.
আরে বাবা আমার জমাটা আর কি
Kindly
taking leave for 5 minutes.
non-quali as agent, extraordinary date on non-medical, and it implies those 809 days be regarded as non-qualifying service. Malad, it has reached height. They regularized it, but they accepted. They got their jail term way before the division bench. Now they are trying to go behind the order of the single judge as well as order of the division bench, which happened in 2003. Now, then Malot, kindly next, page 5.
Yes.
According to geo number such and such, in case of extraordinary leave availed by an employee not for medical grounds. Why they are now claiming it in non-medical ground, going beyond the record, because they now try to cover, bring me under this smaller circular. Non-medical grounds, the benefit of 18 years of continuous service or 10-20 years continuous, as the case may be granted if the total period excluding the period of extraordinary leave is not less than 18 years or 10 maybe, and the non-service period of UL is duly condoned by the appropriate authority prescribed in this regard. Then, when the period of extraordinary leave exceeds 1 month, I am not coming. Last C, in case of extraordinary leave 1 year or more, no benefit will be granted on 1st July, but he shall be eligible for annual increment with effect from next July. Then, 6, my lord. Then say that it is to be.
Yes.
I don't know how on earth, my lord, it can be done. My lord, that judgment, you will see referred the division bench judgment, most probably this one. That is in state of West Bengal versus Kali Sadhan Bhattacharya.
Yes, Kali Sadhan case.
I'm thankful to my learned friend, my lord, he provided me. এই প্রিন্টারের লোকটাকে ডাক না, এটা কি প্রিন্ট হচ্ছে?
Yes, that's all.
That's all. And may I take your lordship's leave?
Yes.
Being the school authority, I may not have much thing to say, because our calculation was that there was a delay, there was a absence of 809 days that we have already indicated. And that 809 days absence.
You change, there is two, you say there is two contradiction and lack of clarity, and at one place, leave, medical leave. At one place, non-medical leave.
That can be sorted out if your lordship stands to order dated 21st of March 2024, which has been shown by my extreme learned friend before lordship. The first page, last paragraph, Ms. Bhattacharya, learned advocate for the board, submits that the resolution of the managing committee of so-and-so Murshidabad for regularization of the 809 days leave of the petitioner has been approved by the West Bengal Board of Secondary Education as extraordinary leave on medical ground without pay. Now, if it is my lord approved as extraordinary leave on medical ground, then the case is otherwise. If it's only extraordinary leave, the consequence is different. Let this document be produced before lordship. Because
which document?
The document by which the board approved the leave, because that is the ultimate document. Once the leave is granted or approved by the board, neither the school authority.
Court will take care of.
It was not by submission.
Not the state. Nobody can say anything, my lord.
I'm grateful, my lord.
An issue which prima facie appears to have been.
And one thing, my lord.
You, Mr. Jahan, come to page 62.
Yes, my lord.
Got it?
Yes.
At bottom portion.
Yes, my lord.
Contradiction.
From 12th of February 1992 to 12th of February 1999.
Medical leave with full pay, 9 days.
Yes, that's a different day.
And right hand.
Yes. Then, my lord, then kindly.
Leave without pay on non-medical grounds.
This is different. Days, kindly have a look at days. Just prior to that, 25th of April 1999, then 6th of June 1999, and this is for 12th of February 1999. The days are different.
Okay, Asunto.
Then kindly come to page 64.
Whether in this matter, Mrs. Bhattacharya entered appearance.
Yes. 21st of March, 21st.
So, yeah, ask, I am seeking report how matter, whether after cessation of master servant relationship anything can be recovered or not. And whether erroneously anything was paid to you or not. Or they will be directed to go on paying based on such erroneous calculation. That is another aspect of the matter.
Knowing that I am not discharging my duty matter, if I take the salary for that period, that whether it will amount to a mistake on the part of the state or not, that also has to be taken into account. I do not render any service. I do not come to this court. I have taken the fees from my client. That is, my lord, also a mistake on my part. So that cannot be subject to the Rafiq Masjid.
Rafiq Masjid judgment.
Let them argue, my lord. I'll show, my lord, what.
No, they are saying that they have not taken any amount. Yet you have claimed that he has done excessive pay. He has not drawn any pay. He is saying that I have not drawn, I have not given any salary. It was without pay. Basically, it was without pay.
School is in Murshidabad. I was in Calcutta. My lord, if I don't go there and draw my salary, how they could? If I was absent, no question of drawing any salary.
Oh.
There's no digital.
But your conduct is not.
Why, my lord?
Your conduct is not good.
Why? I'm just putting a question to myself. My conduct or my client's conduct?
Your client's conduct. I do not, court do not say anything to the learned advocate. Always.
She was.
We in criminal matter we say why this knife was found in your possession.
I was just putting as a remark.
So it is indicating that you have committed this offense. That means whether the learned advocate has done that thing.
But in fact, she was at that time really suffering because of the ill health. That is why, my lord, she could not, my lord, attend the school during that period. 5
years means how many working days in a school?
409 days, my lord, something like 438 days.
Oh. Almost 700 days. 5 years.
She was.
That means per year 140 days he has availed of the leave.
Yes, that I didn't.
Per year 140 days means 3 months and 20 days. That in a year he has availed of leave of 3 months 20 days.
Maybe because of
in every year.
Because of illness, my lord, I am told. I have no personal knowledge.
Okay. You take back your. Next.
Item number 15.
Hey, it is state. It is state. Yes.
May I please your lordship?
Yes.
My lord, may I please your lordship, my lord? My lord, I beg to appear for the petitioner, my lord. My lord,
other side.
my lord, other side has appeared. I have given a notice to them, my lord, about the mentioning also, my lord.
Third wife.
Third wife, my lord.
Claiming family pension.
My lord, no, she.
Other two have died.
Other two have died, my lord. She was getting her part of the family pension, my lord, after the demise of the second wife, my lord.
After the demise of second wife, now he is claiming the full amount.
Full amount, my lord. She is the only surviving heir, my lord. She is having a stepdaughter, my lord, whose claim has been rejected by the order impugned before your lordship. She has not come up before your lordship, my lord, claiming her right, my lord. So, my lord, today this is the situation, my lord, and there is a recovery. Lordship, in the last matter that your lordship was hearing, my lord, lordship referred to two judgment, my lord. One was a Rafiq Mashi, my lord. I am covered by paragraph 18, clause 2 of that judgment, my lord, which precludes the employer, my lord, from making any recovery from a retired employee, my lord. This is a family pension, so my lord, it will apply with vigor, my lord. In case of a family pensioner, my lord, that a recovery, if it is not permissible for an employee, my lord, if fortiori, my lord, it cannot be made applicable.
Everything has two sides. Why you are asking the court to think it recovery? Rather, you prove your entitlement to get the full amount.
My lord, in that
You are saying one glass, if you fill the half of it, anyone can say half fill and anyone can say half.
I bow down, my lord.
Now you are saying that since I am giving a portion of the family pension, portion of the entire family pension, I am being deprived of, and the rest person is being recovered from me.
Yes, my lord.
It is your thinking.
My lord.
But you prove that you are entitled to full, to the full extent.
My lord, kindly consider this judgment passed by Honorable
Yes.
Cabinet Bench for that.
You are the third wife
Yes, my lord.
of the employee. Now, in case of death of other two, you will get the full paragraph.
My lord, it's a short judgment. May I place the entirety of it, my lord?
Yes.
My lord, the material facts of the case have been recorded in my order dated such and such. It is not in dispute that the first wife of the deceased teacher passed away on March 19, 2002 without leaving any children. The District Inspector of School, Primary Education, South Chobbish Parganas, being the respondent number 4, rejected the petitioner's prayer for disbursing the first wife's share of pension in her favor, relying on a clause in the DCRB scheme 1981, which reads as follows. Where an employee is survived by more than one widow, the family pension shall be paid to them in equal shares. On the death of widow, her share of the pension shall become payable to her eligible minor children. If at the time of her death, a widow leaves no eligible minor child, the payment of her share of the pension shall cease. Learned counsel for the petitioner submits that the said clause has been modified by the notification number 54 FPEN dated January 13, 1997, which provides that if the widow is not survived by any child, her share of the family pension shall not lapse but shall be payable to the other widows in equal share, or if there is only one such other widow, in full to her. My lord, this is where I am emphasizing, in full to her, my lord. I have seen the notification and I agree with the learned counsel for the petitioner. Learned counsel for the state, in his usual fairness, leaves it to the court to pass appropriate orders. In view of the aforesaid notification, the order of the respondent number 4, which is impugned in this writ petition, cannot be sustained. The impugned order is set aside. The respondent 4 is directed to take a fresh decision in the light of the aforesaid notification and in the light of the observations made in this order within 4 weeks from the date of communication of this order.
Okay, your prayer was rejected.
Yes, my lord, my prayer was rejected by the order impugned.
Page.
My lord. My lord, page 62 of your lordship's brief, my lord, annexure P14.
Yes.
My lord, kindly takes the, my lord, rule have been quoted, my lord, and kindly takes, my lord, page 63. After the rule is quoted, my lord, chapter 6, rule 26, which have been also quoted here, my lord, is also quoted. Then it says, may I place it, my lord?
Yes.
As per the above order, Ashera Khatun is not eligible for 2 other wives' share of family pension after their demise. However, she may be instructed to proceed. This is where, my lord, the finding is, my lord. That Ashera Khatun is the petitioner before your lordships, my lord, that she is not entitled to the share of the other wives, my lord. Basing on that rule, my lord, which is also quoted in the order that I just placed, my lord.
And another rule, rule 28.
28 is rejection of the claim of the stepdaughter, my lord. 28 is not applicable, my lord. That is the rejection of the claim, my lord, which was in my favor in a way, my lord. That the stepdaughter's claim has been rejected, my lord, based on rule 28, my lord. As per above, last line, my lord, as per above rule, my lord.
You are claiming that you have a stepdaughter.
Yes, my lord.
So let the share go to the stepdaughter.
Yes, my lord, provided she has challenged this order. She has not challenged this order, my lord. She is also a party to this writ petition, my lord. She has been served.
Now you are seeking benefit in lieu of deprivation of your stepdaughter.
That is true, my lord. That is true. That is true. That is true, my lord.
Step is there. মতো মায়ের মতো তো মা তো নয় Yes, Mr. Dole, you appear in this matter. Presence of state is required.
My lord, there is another order which also quotes the same memorandum, my lord. That notification.
Ajay, having heard the learned advocate appearing for the petitioner,
Yeah, my lord.
yes,
Now they initially paid the full amount to me, my lord. After the
it
demise.
should be tantamount to give entire relief in the interlocutory stage.
No, I am not paying the entire relief. I am paying my share, my lord. Kindly take one document, my lord. One document.
The employee had 3 wives.
My lord.
He was survived by 3 wives.
Yes, my lord.
All the 3 wives applied for
My lord. Within 7 days, my lord, the first wife died, my lord.
The first wife died.
My lord, may I give the dates, my lord?
The first wife died. Okay.
Yes, my lord. Date
First
of the
wife died immediately there.
yeah, my husband died on 37/2003. First wife died, my lord. 2003, my lord.
2003. Yes.
And the first wife died on 9/8/2003, my lord. Within
2003. Yes.
10 days, my lord.
Yes.
My lord,
Then what happened?
Then the pension was divided in 2 parts.
Yes, pension was divided in 2 parts. Yes.
Petitioner and the second wife, my lord.
Pension 2 wives.
Yes, my lord. Thereafter, my lord.
Equal share.
In equal share, my lord.
Thereafter,
my lord, the second
wife died when?
My lord, 13/9/2017.
13/9/2017.
Yes, my lord.
Yes.
Thereafter, my lord, I was given the complete share of the pension from 3,863. I was elevated to 14,137.
Following the demise of second wife.
Yes, my lord.
You are given
full pension, my lord. This is
full
what
pension.
Yes, my lord. This is what they are trying to recover now.
Full family pension.
Yes, my lord.
Now what happened?
It started
now
from
how litigation started?
This started from March 2020. I was getting the full pension, my lord.
Yes.
From April 2020, my lord, it was 9,000 plus DA. 14,000 per month and then 9,000. Pension, my lord, stopped. They stopped my pension from May 2022 suddenly, my lord, without any notice to me.
Okay.
After they stopped this pension, my lord, then, my lord, respondent 6 communicated first time to me after a gap of June, July, August, September. In September 8, 2022, after 4 months, they made the first communication after stopping my pension, my lord. No, I didn't get pension for last 4 months in that period of time, my lord. Asking for consent for recovery. This is the first communication they sought from me, seeking my consent for recovery. After that, my lord, before I could even reply, they started deducting my, they again restarted the pension by deducting the amount. So thereafter, my lord, I filed a writ petition. Writ petition was, in that writ petition, earlier round of litigation, it was directed to be considered, my lord. That consideration is the order that is impugned before your lordship in this round of litigation, my lord.
That you are not entitled?
That I am not entitled, my lord. So the
not entitled to any amount?
No, to the other's wife's share, my lord. To the other's wife's share, I am not entitled, and they are continuing with the recovery, my lord. I am getting a paltry sum of 2,500, my lord. State is enriching, my lord, at the cost, at my cost. State is enriching, my lord, at my cost. They are taking my amount, they are taking the shares, others.
They are taking cue from Mr. Dhol. Oh,
My lord, kindly seize the recovery bill once, my lord. That is as page, my lord. 60, my lord. Kindly seize. My
widow of, you are the assistant teacher.
yes, my husband was my
Widow
lord.
of an employee. Widow of an employee.
For 8, my lord. Well, the matter is also fixed on the second
But
half.
that's like your lordship gives any indulgence, because of that, he is a completely paid, he is not a position to act any of this. Though the petition has already sanctioning authority, sanctioned the petition.
Kumaresh Sarkar is, no, Kumaresh Sarkar is in bedridden.
78.
And Kakuli Gain?
That is not by mention, that matter can be posted by after my lord, can be from
No, এই এক কাজ করুন তো শুনুন এই কালকে না এই দুটো যেন হয় একটু আগে দিকে দিয়ে দেবেন তো 16 এবং 17 asked him it is taken up
My lord, there is no issue, only as matter is fixed on the second half before quotum number 8, my lord, nothing else.
second half I have
I know my lord, this second half.
urgent side matter 20 or 21 matters, hearing matter. Most probably I shall not be able to take up the appellate side matter. Okay, so tomorrow এই কালকে কালকে কি মোশন টোশন আছে কিছু এগুলো এমন এক জায়গায় দিয়ে দেবেন যে এগুলো থাকবে তাহলে এই দুটো ওপরে দিয়ে ঠিক আছে এই দুটো ওপরে
I am not
appearing in this matter? No, item number 1.
No. For judgment, item number 1.
There's none. Therefore, for the aforesaid reason, in my considered view, the petition is not liable to be entertained. Since it has been held to be non-maintainable on the ground of inordinate delay and non-joinder of necessary party, entering into the merit of this case would serve no useful purpose and is thus unwarranted. Consequently, the petition and the I number GA 1 of 2025 are thus dismissed. However, there shall be no order as to the cause. এটা লম্বাই করেছে কেন? এটা পাঠিয়ে দিচ্ছি ছোটতে করতে।
So for rule in contempt, item number 2.
I am for the petitioner. On the last occasion, your lordship directed me to serve the copy of the contempt application
Yes.
upon the alleged contemptor for violation of your lordship's order, my lord, dated
Alleged contemptor, my lord,
First
we have filed an appeal,
8/2025.
my lord. We have filed an appeal before the against the impugned order, my lord.
This is a change of rule of game in the midst of a promotional process whereby your lordship was pleased to set aside the entire selection process and directed the respondent.
List with liberty to mention.
No stay has been granted.
Eh?
It has
Copy
never-
has been
I have been served with a copy.
I know, but
No stay has been granted. It has not been enlisted even.
your name, please.
Priyanka Kundu.
আচ্ছা, মিস কুন্ডু লার্নেট অ্যাডভোকেট এই লিখুন। মিস কুন্ডু লার্নেট অ্যাডভোকেট at the outset, comma. Miss Kundu Lagnet advocate entering appearance on behalf of alleged contemner or contemners.
My lord, there is only one contemptor.
One contemptor.
Alleged contemner submits that the assailing the order, comma, violation of which is subject matter of this present contempt petition, comma, and this petition.
For the
You are for the petitioner or
No, I'm for the petitioner.
respondent?
It's for the petition. We are for the bank loans.
Yes, yes.
In this matter,
Last week, sir, Lordship, we have, Mr. Mujumdar has raised the point, Lordship, regarding maintainability of the writ petition, Lordship. Admittedly, Lordship, writ petitioner was a workman under section 2S of the Industrial Disputes Act, Lordship. Therefore, Lordship, he has the remedy before the learned central government industrial tribunal. Since the bank has the Lordship central government, that's why Lordship, his remedy is before the central government industrial tribunal. If the bank is not under the central government, Lordship, it will come under the state tribunal, Lordship. So, Lordship, this.
In which post he is employed?
He's a clerk.
he was a clerk.
Clerk, Lordship.
Clerk. Clerk is one.
And last.
Clerk is one man.
Workman.
What is his salary?
Salary is not a factor here.
It's okay. I mean, I'll address your lordship on this point. They've taken this point, and I'll.
Have you bought the book?
Yes, Lordship.
2S.
2S, Lordship. May be permitted to hand over, Lordship.
Give the 2S.
Yes.
Supervisory and 40,000. Huh?
He's a clerk. He's a clerk. And admittedly, Millard, I'm not saying, just a minute, please. Okay.
So you approach.
My client is superannuated. He's suffering from cancer. And I'll tell you, Lordship, this is Mr. Majumdar himself had taken this point before the court, and that's the reported judgment. And I'll show you, Lordship, that judgment as well. And I'll show you, Lordship, the other provisions also. Now, since he's raised this point, I'll address yourself, Your Lordship, on this point first. If he just worship or worship.
So show the judgment. There's the judgment.
I'll start from Waited. Now, we praise. So there was another case where he had taken this point also. That also I placed that judgment before Your Lordship, but then Your Lordship was not satisfied because it did not lay down any ratio. So that was in the case of Joyati Banerjee, where he had also taken a similar point. And the Honorable Court said that this is alternative remedy, and therefore the Honorable Court is not barred. Now, Millard, I will start with this, Millard. If Your Lordship kindly takes this book here, this is Craze on statute law. Now, if Your Lordship kindly sees, this was a case where, Millard, decisions were made as to whether there's a special effect, the statute law, whether it would override the general law. And in spite of the specific provisions there, here it is, if Your Lordship reads to that chapter, but I would not like to waste Your Lordship's time on this. It was whether the common law is ousted totally, whether equitable jurisdiction of the courts are taken away. Now, Millard, if Your Lordship kindly reads this, this is where it starts from.
Yeah.
And then after that, I'll come to the Indian cases. The provision by a statute.
1 minute. Yes.
The provision by a statute, if Your Lordship has got that, I flagged it.
Yes, yes. Yes, I have got your point.
That's what
I have got your point. He's giving answer. He's giving answer to the point raised by you.
I'm really addressing that point.
Oh, okay. You continue.
Yes. Now, if Your Lordship sees, it's marked there. I'm sorry, my book is heavily marked. Anyway, in Dr. Foster's case, it was held in a writ of mean. The process at common law was distressed infinite. And although the statute of Westminster II gives more speedy process, and in the end, for judger, yet the plaintiff may take which process he will, either the common law or or upon the said statute. Now, thereafter, Millard, we come to the next one. In Great Northern Fishing Company versus Edgehill, the question arose whether Section 4 of the Employers and Workmen Act 1875 gave any remedy against a seaman for breach of his contract in the face of the provisions of the Merchant Shipping Act 1854. Field J said, the duty under consideration in this case is an ordinary obligation to perform any and ordinary contract of service, to the breach of which has been annexed the general remedy by action in favor of the employer ever since the contract of service itself. In order, therefore, to be able to hold that the employer is deprived of that remedy, the mere annexation of a new specific remedy would not by itself be sufficient. It must also appear from the statute to have been the intention of the legislature that the general remedy should not coexist. So he cannot point out from that, from the Industrial Disputes Act, that the remedy before a writ court is barred. Now, next minute, if your lordship sees that the statutory right could, without very great inconvenience, this is when the writ court will not be able to exercise its jurisdiction. That the statutory right could not, without very great inconvenience, coexist with the ordinary common law right, and so must have been intended as a substitutional, not an additional remedy. So this is not, we are talking about an additional remedy, that is the writ court. Now, if your lordship kindly comes on these lines, though this was not noticed, but I'll tell your lordship, give me that. Yes, UN Pandit Abarko. This is the case of Eastern Coalfields, where Mr. Majumdar himself appeared. And this is where the court said that yes, para 12. In the course of hearing, I categorically asked the learned advocate for the respondents that whether Eastern Coalfields Limited as a state within the meaning of Article 12 of the Constitution of India. The learned advocate for the respondents clearly submitted that Eastern Coalfields Limited is a state within the meaning of Article 12 of the Constitution of India, and it is not his case that Eastern Coalfields Limited is not a state within the meaning of Article 12 of the Constitution of India. Admittedly, the writ petitioner was a workman within the meaning of Section 2S of the Industrial Disputes Act and employed by Eastern Coalfields Limited. Does this aspect of the matter make any difference? In my opinion, it makes a world of difference. It is now well settled by a decision of Constitution Bench of the Supreme Court in Ojai Hasia, the celebrated case. AIR 1981 Supreme Court 487, that merely because a juristic entity may be an authority and therefore state within the meaning of Article 12, it may not be elevated to the position of a state for the purpose of Articles 309, 310, and 311, which find a place in Part 14 of the Constitution. In Ojai Hasia case Supra, it was clearly laid down that a juristic entity which is a state within the meaning of Article 12 of the Constitution is limited in its application only of Part 3 and Part 4 of the Constitution, meaning thereby that the provision of Part 3 and Part 4 of the Constitution of India are applicable to a juristic entity which is a state within the meaning of Article 12 of the Constitution of India. The relevant lines from the decision of Ojai Hasia case are quoted here and below. It is also necessary to add that merely because a juristic entity may be an authority and therefore state within the meaning of Article 12, it may not be elevated to the position of state for the purpose of Article 309, 310, and 311, which find a place in a Part 14. The definition of state in Article 12, which includes an authority within the territory of India of under control of the government of India, is limited in its application only to Part 3. And by virtue of Article 36 to Part 4, it does not extend to the other provisions of the Constitution, and hence a juristic entity which may be state for the purpose of Parts 3 and 4 would not be so for the purpose of Part 14 or any other provision of the Constitution. Thereafter, my lord, The above quoted lines from Ajay Hasia was relied upon by the Supreme Court and Air India's Shoinik School Employees Association. Was this so and so? Thereafter, once it is held that the Shoinik School Society is state within the meaning of Article 12 of the Constitution, application of Article 14 is retracted. Similarly, under the directive principles, the claim for equal pay for equal work becomes tenable. Thus, it is well settled principle of law that an employee of a state within the meaning of Article 12 of the Constitution can initiate a proceeding against the employer if his fundamental rights guaranteed by Part 3 of the Constitution of India are violated. My God. I'm sorry, Militant. Are violated by the employer. This being the position in law, the workman within the meaning of Section 2S of the Industrial Disputes Act 1947 of an employer who is a state within the meaning of Article 12 of the Constitution of India can initiate a writ proceeding when his fundamental rights guaranteed by Part 3 of the Constitution are violated by the employer. Thus, a workman within the meaning of Section 2S of the Industrial Dispute Act 1947 can initiate a writ proceeding against his employer in a state within the meaning of Article 12 of the Constitution of India when the disciplinary proceeding is arbitrary and therefore violated the provisions of Article 14 of the Constitution, and when he is deprived of his livelihood not in accordance with the procedure established by law, thereby violating Article 21 of the Constitution of India. In such type of cases, I'm of the view that even if the workman could have raised an industrial dispute under the provisions of Industrial Disputes Act 1947, that would not prevent the workman to move a writ application when his fundamental rights under the Constitution are violated. In Whirlpool Corporation case, it has clearly been laid down that availability of alternative remedy in a case of breach of fundamental rights and breach of principles of natural justice or action taken without any jurisdiction would not at all stand in the way of an aggrieved person to initiate a writ proceeding in the High Court. Whether the fundamental rights of an employee guaranteed by Part 3 of the Constitution of India have been violated or not can only be violated or not.
To come to the point.
Yes, this is the point. Therefore, the finding of the court.
Article 226 does not contain any fetter or bar, either on the count of limitation, delay, or on the count of existence of alternative remedy.
And
despite it is well settled that despite existing or alternative remedy, a writ court can entertain a writ petition. But subsequently, the court evolved a concept of self-restraint. Self-restraint, it is none.
Whether that discretion.
The constitutional maker did not impose, do not think it to impose any embargo or fetter on the writ court to proceed. Okay, court can, but subsequently self-imposed restriction, willful judgment, and many other judgments, you know. And lastly, the court has reached to a conclusion where we will come with the allegation of violation of principle of natural justice. When he will come that they have acted without jurisdiction, yes. When he will come that ultra vires, it is ultra vires. Because the decision whether any statute or act is ultra vires cannot be relegated to a tribunal. It is the constitutional court to decide the same. And many other violation of.
We can multiply this. We can multiply.
And multiply, no, not. Court has specified certain reason.
Because I will not.
It is not that. It is not that the list is.
No, I will not be.
So
I will not be canvassing.
So the putting of embargo on the self-imposed restriction will be mere fertile.
Yes. But I will not be taking. I'll be taking your lordship through jurisdiction.
But there is a judgment in Satyavati Tandon's case and another case that when statute has made a remedy, court will exercise itself. Impose restriction, self-restraint. When statute,
So that I had shown your lordship.
When to address the grievances of a workman within the meaning of section 2A of the Indian Industrial Dispute Act, the legislature think it fit to legislate a specific enactment, then a writ court should,
I have not had a copy of this.
yes, writ court should exercise its self-restraint.
Sir, in this,
Okay. Because a writ court is a summary proceeding, admittedly, and writ court has realized that it cannot go into the disputed question of fact,
which I'm not.
where evidence is required to determine the question. So in that circumstances, writ court should exercise self-restraint and should ask the fact-finding authority or the tribunal, you determine the issue.
But here, beloved, I will.
Okay,
I will
but it is not remedialess. If he aggrieved by the decision of the tribunal, writ jurisdiction is always open to him to be invoked. Okay, but let the fact-finding authority decide first. Then, if the find that there was a irregularity or illegality in decision-making process, High Court is here.
Now, beloved, I will tell your lordship what. I am not going into any disputed questions of fact. First of all, I'll be going into jurisdiction. Number two, Millard, I'll answer your question, your lordship's whatever has fallen from your lordship. Now, this Industrial Disputes Act was basically, it was enacted to protect the workmen. Now, before that, if I could file a civil suit. But this was a specific remedy that was granted against a private employer.
And provided for a separate mechanism.
Here, the employer is not a private employer. That's why we could first. It was before the insertion of 2A. The whole dispute had to be espoused by the union. Thereafter, 2A was inserted and saying that only one workman could do it. But here, this is a state.
In respect of United Bank of India coordinate bench.
This does not
coordinate bench.
Yes, but it has not considered the judgment which I have given you, lordship. It's not decided there. No ratio is laid down. No ratio is laid down. No, it was threshold because this judgment was not considered. I can only say I should not be saying it. I can say that it is per incurium. Because this judgment stands on the way. This is also a coordinate bench judgment. Now, Millard, if I can go on before your lordship with this.
No, you come to another, or any decision is
yes,
there?
another division bench judgment.
Yes, so the division.
Another division bench judgment. 1969 SCC. 1970 Lab IC 323. May I have that copy? I have just a minute.
1970.
Yes. No, but there is something here. It was okay. It's okay. Bank nationalization, in fact, helps me because it becomes Article 12. It becomes Article 12.
It is 170.
Yes.
1970, sorry.
1970, yes.
At that time, bank has not been nationalized.
Does not matter because bank was. What I am saying is the basic principle. Now, if your lordship kindly reads this, it appears from the plain.
What is the matter? What you have challenged? What is the
challenge the order of dismissal as being without jurisdiction? As being without jurisdiction.
Since I have said without.
No, that will be. I'll show your lordship that.
To keep the petitioner as on duty.
Yes.
During period of suspension and pay full.
Yes.
You are service-related dispute.
No, this is a
service-related dispute.
Go further.
The disciplinary action you have challenged.
No, I'll tell you.
You are aggrieved by the disciplinary action taken by the bank against you.
happened is,
Fundamentally, in
fundamentally,
essence, you have challenged
what
us.
happened is,
Huh?
now, if your lordship sees that they are bound by the, I'll show your lordship other judgments also on this. On the Supreme Court judgment, if your lordship reads the 1970 judgment, the principle is laid down there. What I showed before your lordship from Craze, that is reiterated there. That is in fact reiterated. It appears from the plain, if your lordship kindly takes paragraph 2.
Yes.
It appears from the plain, including the amendment, that the suit was for recovery of damages on account of wrongful dismissal. Now, this is against.
It is a civil division case.
Yes, then the grounds alleged for wrongful dismissal in question being grounds on which suit was clearly.
The proposition whether a suit can be instituted under section 9 due to express bar or not, that principle don't bring it. Don't borrow that principle. You file that, you satisfy the court that the Article 226 has not imposed any bar. Okay. Now I have stated, and hence I want to confine your argument to the pattern point that Article 226 has not put any embargo and restriction on the court to entertain a writ petition.
This was the
due to existence of alternative.
This was the first judgment.
Excuse my repetition. Subsequently, over years, through the applications of various judicial principles, this concept has evolved, and we yourself evolved in this concept. None the legislature has not said, administration has not said. We, the judiciary, has realized that due to existence where the statute has provide for an alternative remedy, we should exercise self-restraint. And we should apply the concept of self-restraint, doctrine of self-restraint.
If I may,
Securitization Act, specific remedy has been given. Industrial Dispute Act, specific remedy and mechanism has been given to address the grievances of the workmen.
Now, Millard, if your lordship.
So, in the circumstances, why court shall not exercise in your case that self-restraint you satisfy?
This judgment itself, which I first handed over.
It is a civil division.
Oh, okay, we can ignore that judgment, Millard. If your lordship kindly comes to the first judgment.
I am again saying don't try to borrow the principle.
By here the Eastern Coalfields matter. The whole thing is there as to why the court should entertain. Now, if I may read on.
It is not a writ matter, not in respect of writ.
This was a writ matter.
Not in respect of writ. Civil division cannot be writ.
I'm not the first one. The first one. Pandey. UN Pandey.
There is judgment of willful and many other judgments.
Eastern Coalfields matter. They are a similar provision. There's a question as to whether workmen can agitate before this honorable court. A question of dismissal that was taken up. That is the Eastern Coalfields matter. That is what I was reading. The one which I first handed over to your lordship.
There cannot be any quarrel that in accepting this proposition that workman can accept. Again, I am saying, if the workman challenge that this provision is ultra vires, he will come. His only remedy before the jurisdiction.
Yeah,
if he says the principle of natural justice has been violated,
look, this was a case.
If he says that the authority which has taken action has got no jurisdiction.
Exactly.
Yes, he will come.
The order of dismissal, which I am.
But fundamentally, you have challenged the disciplinary action taken against you by your employer, being a bank.
May I,
and admittedly, you are a workman.
May I?
Yes.
May I yes. Here, in this case, there was this disciplinary proceeding which was taken. Simultaneously, there was a criminal case which was filed against him. He was acquitted from the criminal case. The appeal was kept pending.
Appeal before the?
For the statutory authority.
Yes.
Now, the appellate authority does not take into consideration my acquittal from the criminal proceeding. Now, if he did, the order of the disciplinary authority could not be sustained because of the clause in the bipartite agreement. This is the simple question.
Because of the clause of
the bipartite agreement, which says that if he be acquitted, then he can't be dismissed from service. That is my point.
At this point, you can agitate before the tribunal also.
Look, this is a simple.
So the statutory appeal is pending.
No, statutory appeal is not pending. I came up before this honorable court so that my statutory appeal could be, after 10 years, could be disposed of. Then it was heard.
Then dispose of taking note of your subsequent acquittal.
No, it was not.
Huh?
It was not.
Appeal is still pending.
No, that has been disposed of. I'm challenged that appeal is still.
That has been disposed of. There is any provision for revision or review, anything? No provision. Now you have challenged the final order of punishment and the appellate authority.
Yes, because of the fact that after acquittal from criminal proceeding, this sort of an order cannot be sustained. Now, if you're
okay,
that is the basic point.
Okay, Ramlal judgment. Give the Ramlal judgment.
Ramlal is also.
Ramlal brought it. Ramlal.
I have not brought Ramlal, but Ramlal has been referred to by
subsequent judgment.
It's 2025 judgment.
Yes. Same principle, Ramlal judge.
Same.
But
But
in that case,
কি করছে এখানে আছে নেই করছিস কেন এখানে পড়ে আসলাম কোথায় গেল এই তো এইটা বার করো I can't give this one. Give the other one.
yes, he was terminated. Yes.
এটা তো আছে Ramlal judgment says there is no benefit of doubt. There is no benefit of doubt. Please, if you keep on saying, then you please keep on saying.
No, I am saying.
You keep on interrupting.
I am saying, have you bought the Ramlal judgment? It could have been.
It has been referred to here, will it? And if your lordship sees the order of acquittal,
the set of witness is to be same.
Yes, they were the same.
The allegation is to be same.
Lord, if your lordship.
Ramlal judgment cannot be blindly applied.
Your lordship need not apply it at all.
Application of Ramlal judgment subject to fulfillment of certain conditions. It is the yes, Maulana Pratap Singh, same. Maulana Pratap Singh.
I'm sorry,
yes.
Lord, this is
this judgment.
I have
Ramlal judgment, but
unfortunately, Lord, I have not got another copy of this.
Okay, I am trying to.
But I have made my notes there. If your lordship kindly see
I am
but
trying.
Before we traverse these judgments,
you take me to that portion that.
I think that
same set of
paragraph 50. I think
same set of at least most of the witness are to be common. Allegation is to be said. What is your allegation? Tell.
My allegation is this. If your lordship sees, your lordship need not even look into that judgment, except Ramlal, because it's where the court has said, that is 50, I think. Paragraph 50, if your lordship sees. I have made my notes there at the bottom. First three to the kindly looks to that.
It is
the bipartite agreement by which everything turns on that bipartite agreement. Obviously, there is an acquittal. Now, if your lordship sees C, if he be acquitted, it shall be open to the management to proceed against him under the provisions set out below in clauses 11 and 12 relating to discharges. However, in the event of the management deciding after inquiry not to continue him in service, he shall be liable only for termination of service with 3 months' pay and allowances in lieu of notice. And he shall be deemed to have been on duty during the period of suspension, if any, and shall be entitled to full pay and allowances minus such subsistence allowance as he has drawn, and to all other privileges for the period of suspension, provided that if he be acquitted by being given the benefit of doubt. This is not my case. I have not been given the benefit of doubt.
Give a copy of this.
That is the thing. And then after that, if you want to
give a copy. And you give the reference citation of Ramlal. I shall take it out from my.
Ramlal is cited there. If your lordship kindly give
yes.
I'm very sorry, Milord.
I can take out from my laptop.
Paragraph 50.
Paragraph 50, you tell the year.
Is there in that judgment?
2024, column 1 SCC, page 175.
Neutral citation আছে।
One minute time. So condition is that both the disciplinary proceedings and criminal proceedings based on similar set of facts.
That I'll show you.
Similar set of facts, if you ask. Now, charges before the disciplinary proceedings and charges before the criminal court are same. Now, the set of witness, the main set of witness are to be same. Here, witness are chosen by the IO, and here witness are chosen by the prosecution or by the person who issued the charge sheet. So, two are different persons, but set of witness, common witness are to be same.
In my case,
you show that in your case, this condition fulfilled, then you will get the benefit of.
One more thing. In my case, before the disciplinary authority, the persons whose allegedly whose signatures were forged and from whose accounts I have withdrawn money, they were not produced before the disciplinary proceeding. But in the criminal proceeding, they were produced.
They
were produced.
Produced. What they deposed against you?
No. They said, no, there is nothing. I'll read those things. And my case is also not based on that also, not even Ramlal. Because of the fact that here, where your lordship is just read, if I be acquitted, I go further. This
What was the allegation against you?
allegation was the same.
So take me to the charge sheet.
Yes.
Take me to charge sheet.
That is at page 25.
25.
That's the disciplinary, that's the inquiry officer.
List of the proceeding. It is inquiry officer report.
Yes. Inquiry officer, he deals with the charge.
So inquiry officer can reiterate.
He reiterates the charge.
That yes, charges in brief.
Yes.
25. You are Nityaranjan Mollik.
Yes.
Forge and Sky 5 fictitious credit entries. Such and such. In similar manner, forge or Sky withdrawal of money, delivery.
Yes.
So inquiry officer held that the charge
is approved.
Charges are
Charge is
approved.
always proved.
Okay. Findings were based on that charges against has been committed. Charge stands proof. Okay.
Yes. Now after that, if your lordship
The charge
comes to the
sheet
acquittal.
contain the list of documents, list of witnesses.
Yes.
You
No.
cross-examine.
Yes.
All documents were supplied to you. Okay.
Now we are on this.
Now disciplinary authority agreed with the findings of the
inquiry
officer.
And if your lordship sees
And
page 34, 36.
Page 34. Yes.
36. 35 is the order. 35 is the order. The last order, the 36. 36. During the period of suspension, you are not entitled to any pay and allowances, save and except which have been paid to you by way of subsistence allowance, and the period of suspension will not be considered as qualifying service for all purposes. That means he takes away my pension also.
Yes. Punishment of he proposed a punishment of dismissal from service without any notice. And
qualifying service is also taken away so far as
yes, dismissal means everyone will. You filed a writ petition.
Yes. Now, if your lordship kindly comes.
Writ petition was entertained and shall place all the before appellate authority. Appellate authority was directed to consider your grievances.
Yes. Now, if your lordship kindly comes to page 51.
Prefer the appeal.
Yes, page 50. Before that, page 50.
Page 50, yes.
This is
you are held not guilty and you are acquitted.
Acquitted. There is no question now. This is where Ramlal comes in.
235(1). That is after evidence.
This is honorable.
After considering evidence.
If your lordship kindly minute, I'll take your lordship through that. Your lordship need not. No, there is nothing. At least from a plain reading of this, we don't see any benefit of doubt. And wait a minute, I will canvass this, because if your lordship sees that judgment which I have handed over of the Supreme Court 2025, this particular aspect has been dealt with by the Supreme Court itself.
And subsequently,
and then after that, if your lordship kindly sees the witnesses who were produced, but it will take some reading of this order.
Okay, no.
I'm saying that this is there. Thank you very much. যেটা মার্ক করা আছে আমার এই সেম জাজমেন্ট
In disciplinary proceedings,
now, my lord, if your lordship sees,
in disciplinary proceedings, management produce 6 witnesses.
Yes.
Who are they?
10 witnesses. No, in the criminal proceeding, 10 witnesses were produced.
In disciplinary proceedings.
That I don't have a copy just now.
In disciplinary page 25.
Page 25, of course.
MW1 to MW6.
Yes.
MW means management witness.
Yes.
Management witness 1 to 6. That means 6. Who are they? And hence I wanted to see the charge sheet.
There were 6 witnesses.
Details of
There were
documents
6
are there.
witnesses in the disciplinary proceeding.
Details of
There are
documents.
10 witnesses here.
Yes. You will come page 34. 34 is there. Oh,
Shankarlal Ghoshal, he was produced. Tapan Kumar Sarkar, I think he was also produced. Arun Chandra Bhar was produced. Subhash Chandra Haldar was produced.
okay.
Even the manager
So,
who actually filed the FIR.
Arun Bhar was PW1 before the, yes, Subhash Haldar, I am to do homework for you.
No, but
Subhash Haldar was
Yes, yes.
PW2.
Yes.
Bimal Krishna Koyal. Bimal Krishna Koyal was not management witnesses. Okay, Bimal. Okay, Shankarlal Ghoshal is here.
Yeah, he's
Shankarlal Ghoshal,
He's the main person.
PW9.
He's the main person.
PW9. Thereafter, the year did not discuss. PW5, Sunita Rani Hira.
She's allegedly her signature was forged and her accounts were manipulated. She was not produced at the disciplinary proceeding. Gokul Pal then. Page 60.
So only 3 witnesses. Where is the charge sheet?
Kitish Chandra Mondol.
Kitish Chandra Mondol is not here.
At page 60.
PW7 Kalipodo not.
Kalipodo Paul. These were people who were supposed to be affected.
PW10. So only 3 witnesses are common.
Yes. Main witness is here. The court says
3 witnesses are common both in disciplinary proceedings and criminal proceedings.
Because others might have retired or they may not have. That is up to them. PW9 Shankar Ghoshal, he is the person who was a branch manager when this happened. So he's the star witness. But one thing, if your lordship sees, after the acquittal, the Bipartite does not speak of anything. It says if you are acquitted, they don't go to Ramlal. We go one further. If you are acquitted, this order of the disciplinary authority cannot stand. That is the case. Now, if your lordship now sees the appellate order. Appellate order.
Okay, appellate order affirm the final.
No. They have discussed this. Yeah, I'll show your lordship what has.
Yes.
Show your lordship what's that.
Yes.
Page 67. I'll produce Ramlal also, for your lordship's satisfaction.
Yes.
Because of the fact that I will, since he's saying it's honorable acquittal, though that has also been dealt with in this judgment itself. And I have not handed over Premier Automobiles, which was for the purpose of this. Because I was only asking for a return of that judgment.
Oh,
the other one is found.
Yes.
Oh, neutral citation. তাহলে তো আবার অসুবিধা হবে প্যারাগ্রাফ মিলবে না প্যারাগ্রাফ মিলবে না
Yes, you tell more of both of them. I have referred, I have read, don't worry. Yes.
If your lordship kindly comes to page 67.
67, I am 67.
Towards the bottom.
Yes.
From above, it is to inform Sri Malik that no additional relevant documents were produced. What was produced here was the order of acquittal. That was the the actual cardinal issue. And that has not been considered. Because he is under an obligation, under this act, under this bipartite agreement, to see whether I have been acquitted. If I have been acquitted of the charges, the penalty does not stay. The penalty is without jurisdiction then. Because the absolutely clear here, if he be acquitted, it shall be open to the management to proceed against.
Although the
I produced that.
Fact of your acquittal in the criminal case
was produced,
are brought to the notice of the appellate authority, but appellate authority has not dealt with the issue.
And the whole texture changes. He can't impose that order of punishment.
So what do you want? Whether the matter shall be relegated to the appellate authority to consider?
No, Your Lordship will kindly quash that order. And because I am entitled, wait a minute, because of the fact he has no jurisdiction. No. Because if I am again relegated, how much of harassment will I suffer, Millet? He is terminally ill.
Okay. That's all. That's your submission, I think.
So, Millet, I was going to submit in a different way, but anyway, and about this other.
You just give the photocopy of the book, relevant extract, and where you want to show that there is a bipartite agreement that in case of acquittal, there shall be no proceedings further. Okay.
Not no proceedings.
You get
I'll
it
be
copy.
treated as on duty.
On duty.
I will be getting all the
You will
benefits.
be allowed to rejoin your duty. Now you
not rejoin my duty, Millet.
And have you got the charge sheet of criminal case? Charge sheet of criminal case?
Charge sheet of the Millet. I'll tell you, Your Lordship, this is a changed brief, and this person is told. And no, Millet, one more thing. Your Lordship has got the, boita to dini, boita ache ekhane. Amar boita kothay gelo ekhane.
Yes, you read.
No, I'll hand it. The next page.
I have read this.
After that also.
Yes. Bank workman service condition. Yes.
Once this was also denied by Mr. Mojumdar, then after that, of course, he came back with the same thing. Anyway,
yes.
If after Millet, if Your Lordship sees four.
Yes.
If after steps have been taken to prosecute an employee or get him prosecuted for an offense, he is not put on trial within a year of the commission of the offense, the management may then deal with him as if he had committed an act of gross misconduct or of minor misconduct as defined below, provided that if the authority which was to start prosecution proceedings refuses to do so or come to the conclusion that there is no case for prosecution, it shall be open to the management to proceed against the employee under the provisions set out below in clause so and so. But he shall be deemed to have been on duty during the period of suspension, if any, and shall be entitled to full wages and allowances and to all other privileges for such period. In the event of the management deciding after inquiry not to continue him in service, he shall be liable only for termination with 3 months' pay and allowances in lieu of notice as provided in clause 3b. After that, if Your Lordship sees once more. Now, then I'll be reading the order of dismissal. If within the pendency of the proceeding thus instituted he is put on trial, such proceeding shall be stayed pending the completion of the trial, after which the provisions mentioned in clause 3 above shall apply. Now, whatever it is, they took up the cudgels. They dismissed me from service during the pendency of the trial. They did not stay the proceeding. It's a long-drawn proceeding, so they need not be stayed. But then what remedy is there? But he shall be deemed to have been on duty during the period of suspension. If Your Lordship kindly reads the order of dismissal once, at page 36.
Yes.
Yes, because that is the main thing. No. I have not shown one more judgment also. No. I'm not avoiding. Why should I?
Okay, your point will be addressed.
Just a minute. I'll be
Your
coming
point
back.
will be addressed.
I'll be coming back to the Supreme Court as well. Don't worry.
Okay, your point will be addressed. You consider in a judgment issue specific order is given. Issue number one must be whether it is maintainable or not on this count. If court finds that it is not maintainable, there is no requirement to determine the other issue. But if court finds that it is maintainable, then court will proceed to deal with other issue.
Now,
okay, when this issue is raised on maintainability at the final stage, then court is to decide the issue in this way.
Because this jurisdictional point has also come up before your lordships. That's why.
Yes.
Now, during the period, now if your lordship sees page 36 months. I've read that 19.4, and then see, I've shown your lordships those.
Yes.
Now, during the period of suspension, you are not entitled to any pay and allowances, save and except which has been paid to you.
Yes, I have read.
Of clear violation of their own laws.
Oh.
And then after that, if your lordship, one more judgment, which are the Supreme Court. No, not Premier. It's the other one. Yes, Premier. Yes, Premier. Premier Automobiles. Yes. Look, this is the Premier Automobiles, on which another judgment was passed. Now,
yes, paragraph.
Yes, paragraph 10.
10,
11, and 23.
10,
11, 23, and 24.
Oh. What is the proposition? Tell, what is the
proposition is that when there are the thing which I read before your lordship, in the first place from Craze, the same thing is being followed here by the Supreme Court itself. Same thing. Same thing is followed, that because if your lordship, first we have to visualize that this is an Article 12. Article 12. Bank is under Article 12. That is the first thing which has to be noticed, and that was noticed in the Pandey judgment also.
Yes.
UN Pandey. That was also noticed.
Yes.
So 24, 23, paragraph 23 is
yes.
When there is a choice.
Proposition, yes.
Here the proposition is when there is a choice. The writ court, I can come to the writ.
Okay. Don't repeat.
And
I think you have.
If your lordship wants Ramlal, because he'll take up
Ramlal, I have. I have.
Honorable acquittal, that
Yes, I have.
in fact, I have also dealt with that the other judgment 20.
Okay. No.
Honorable acquittal.
Yes,
dealt with.
Got it. Don't repeat.
Yes.
Your first point of argument is first limb of argument is that if petition is not maintained due to existence. Yes. Workman within the meaning of 2S. Yes. On the basis of the agreement. Section?
And section 8.
215, 215.
2P, Lordship.
2P
and section 18(1)
of
Industrial
of ID Act, yes.
Act read with Rule 58 of the Industrial Dispute Central Rules 1957.
My lord, this was the banking industries, and this is only not to the workman, not to the actual officer, not officer. It is only culpable to so far as industrial employees are concerned. That is the thing. Now we have followed that. Entire proceedings were followed in that manner. Now, what could be the decision of the civil court, not civil court, arbitration,
Industrial Disputes Act.
Not Industrial Disputes Act. Before the writ court, whether it could be taken into consideration. Now, because there is a various proceedings, provisions, which has been given in the rules, and the Industrial Disputes Act, and that is this thing, and it is, my lord, kindly look at it. My lord, I'm reading from one page. Memorandum of Settlement dated 10th April 2002 between the management of 52 A-class banks as represented by the Indian Banks Association and their workmen as represented by the All India Bank Employees Association, National Confederation, Bank Employees, Indian National Bank, etc. Now, this provisions is there. It is not applicable to the service, those who are officers of the company. It is not applicable to them. It is only applicable for these employees.
Workers.
Workers. They are now. I am reading from first of all, disciplinary action procedure, therefore. It is a person against whom disciplinary action is proposed or likely to be taken shall in the first instance be informed of the particulars of the charge against him, and he shall have a proper opportunity to give his explanation, and to such parties final orders shall be passed after due consideration of all the relevant facts and circumstances. With this object, the view follow shall apply. By this expression shall be number 2. By the expression, offense shall be meant any offense involving moral turpitude for which the employee is liable to be conviction and sentence under any provisions of law. Where the opinion of the management and employee has committed an offense, unless he be otherwise prosecuted, the bank may take steps to prosecute him or get prosecuted, and in such a case, he may also be suspended. This is all with the employees and employers conduct. If the conviction, he may dismiss with effect from date of his conviction, he be given lesser form of punishment as mentioned in clause 6 below. If the acquitted, if he be acquitted, it shall be open to the management to proceed against him under the provisions of the said below clause 11 and 12 of the infra relating to the discharge. However, in the event of the management deciding after inquiry not to continue him in service he shall be liable only in termination of the service with the 3 months pay and allowances in lieu notice thereof. And we shall be deemed to have been on duty during the period of suspension and if any, and shall be entitled to the full pay and allowances minus such substances allowances as he has done to the all other privileges for the period of suspension, provided that if he be acquitted by being given a benefit of doubt, he may be paid such portion of such pay and allow as the management may be deemed fit and proper, and the period of his absence shall not be treated as a period of plenty spent.
Industrial disputes Act দেখানো হবে।
Now, my lord, I am showing.
Settlement. Section 2P of the Industrial Dispute Settlement.
Now, my lord, kindly look at the section 2P of the settlement.
Industrial Dispute Settlement.
ID Act. My lordship.
Section 2, subsection P, Lordship.
Yes, got it.
Settlement means a settlement arrived at in the course of the conciliation proceedings and includes a written agreement between the employee and workman arrived at otherwise than in the course of conciliation proceedings, where such agreement has been signed by the parties thereto in such manner as may be prescribed, and a copy thereof has been sent to an officer or otherwise authorized in this behalf. Now, my lord, question is, now these are the provisions that has been given for the clerical employee or industrial in industrial term, whoever will be the workman. So he is a workman. There is no doubt about it.
And this bipartite agreement was made in terms of the settlement.
And the settlement has been made in terms of the bipartite.
Bipartite agreement. So by terms and condition of that agreement is binding upon the petitioner. Yes, I have got your point.
So naturally, that is the point that is to be looked into. Now, so far as criminal action that has been taken against him, this has been gone in whichever way, that is not the fact. That can't be said that he should be allowed to be employed further. It will be not in its same pattern. According to the management, this is the position.
And sophisticated rules of evidence.
And sophisticated rules of evidence act do not apply in this context.
Degree of proof is different.
Sets are different, Lordship. And your Lordship is well aware about the fact, Lordship, the sophisticated rules of evidence does not fall in case of disciplinary proceedings, Lordship.
Yes.
So now in this case,
and another point, there is no there is no most minor point is that no violations on principles.
And it can't be said that there was a violation of natural justice. He has been adequately, he has been
fullest opportunity was given, Lordship, to the delinquent, Lord, during the inquiry proceeding or enter the disciplinary.
Now, if I come to the so far as I may say that banking,
and he has not been prejudiced in any way.
Nationalized bank. That doesn't mean that the provisions that have been given in the selection in the Industrial Disputes Act, and for that matter, the ওটা বলো মানে employer সম্পর্কে যে ইয়েটা
হ্যাঁ ওটা কি বলা দরকার
Principle of natural justice, although the Honorable Apex Court says that it cannot be put
To the hill.
to the hill and cannot be given a status of a statute. But principle of natural justice in disciplinary proceeding, if the relevant materials is overlooked or not considered, it will also violate the natural justice.
Here I'm emphasizing.
If the relevant or irrelevant factor is considered to take decision, or relevant factor is overlooked, then also it will violate the natural justice, principle of natural justice.
There is no violation of natural justice has taken place. He has been.
Our mindset is that principle of natural justice is followed if the opportunity is given to defend.
All the documents are given.
All the documents have.
Yes, if the opportunity is given to defend. Document is supplied. I have given you the opportunity to cross-examine the witnesses, management witness. So, principle of natural justice has been properly followed. I have followed. Not that. In disciplinary proceedings, again, excuse my reiteration, that omission to consider the relevant factors or relevant document or overlooking the same is also violation.
No, I am only trying to say that my learned friend is telling that their government organization. Well, that is not the fact. It does not. It does not imply in this. So far as the private bank is concerned, whatever the process, that will be the process. So far the industrial dispute is concerned, that will be not the process. That's why I'm telling that.
Anything to add?
You will cite some judgment also. You will cite some judgment also. Regarding disciplinary proceedings or criminal proceedings are not the same footing.
Someday I can.
No, you give the judgment to my officer. Tomorrow you give. Take pain to find out today. Tomorrow you give to my officer. Don't worry. All your judgment will be dealt with.
But
okay.
Just in my reply, just 2 minutes. But I have never said that the parameters of evidence should be the same. I have not on that. What I have shown your lordship comes from Muhammad Noor's case, where I have shown your lordship that they have violated their own bipartite agreement by, I showed your lordship, that if I am acquitted, I am not entitled, they are not entitled to impose this punishment on me.
No, my lord,
That
here
is where I have said so. And if your lordship considers Ramlal and the judgment of the Supreme Court, where I have said, my lord, in fact, from Muhammad Noor to Whirlpool to the present day,
my lord,
where
you get it,
it has shocked.
You do one thing, you get it copied. This
your lordship keeps that. As long as your lordship returns that copy.
Okay. I am to refer. Cares I have.
Because this your lordship may not be able to get from your lordship.
This book, এটা থাকবে, এটা
but your lord, I'll take it.
Next Thursday, your lordship fix.
Today it will not be concluded.
Not concluded.
I have finished my reply.
I'll show those.
Today I have.
I'll show those judgments, my lord. That's why I'm.
He can hand over.
Any day.
He can't get out of the fact that he's
violated. Out of the fact.
He's violated his own.
The learned advocate appearing for the respective
own
parties. Leaves the matter for further consideration on 4th September.
My only submission is that he
on 4th
violated.
September, just এটা আপনি করবেন তো to be mentioned দিয়ে দেবেন নাকি? Just submit certain judgment.
And I'll also show your lordship Muhammad Noor also to fortify my. He can produce 10 years.
Again, you re-argue.
So what to do, Millard?
Today you have taken 1 hour 17 minutes.
He's finished his arguments. Then he says, "No, I'll go on."
Okay, on that date, they will. Don't.
I can flood this court with judgments.
On this point.
Yes.
So many matters also my learned senior friend appeared.
That's
Body
why
am
আমার
aware of it.
তারিখ তো হবে না।
The Petition bench judgment is there, Lordship, as well as appeals court judgment is there.
Oh, I am keeping it under the heading to be mentioned. Shall I?
Yes, yes.
Yes, yes, Lordship.
হ্যাঁ?
To be mentioned, Lordship.
আচ্ছা,
Not more than that.
তাহলে আপনি ইয়ে করে দিন, have the learned advocate appearing for the respective party list the matter for further consideration under the heading to be mentioned on 4th September 2025.
As your worship.
Yes, yes, yes.
Deep reply.
Next. Go. Yes.
That we use a supplementary affidavit. Already a petition has been filed, but my lord, my clients, my lord, knows my lord bank.
After argument, supplementary affidavit.
No, my lord, I'm telling you, lordship.
There is a judgment.
I know. No, I know.
That means a chance is to be given to fill up the lacuna.
Yes.
Or to the point to
Raised,
address
now
the
raised,
protest.
now raised. My lord, because bank, my lord, nationalized bank, my lord, the
Without
bank.
filing supplementary affidavit, you address that this point has been raised, and my answer to this point is that.
My lord, may I do this subject to what you're. My lord, may I keep that supplementary ready and serve it? I will not use it unless and until your lordship allows me.
Okay.
One line order will help us.
If they object,
don't look at it.
Satisfied.
Then don't look at it.
After completion of
Senior
how
advocate.
many
He's
times you take time?
engaged
How many times
the
you are
field.
taking time in this matter?
Your lordship, he's engaged in a fixed matter, your lordship. Kindly fix it.
At John.
Grateful, your lordship.
হ্যাঁ? 6 নাকি এটা? হ্যাঁ, 6-11 Yes. Item number 6. এটাও আসছে না অনেকবার?
Several occasion, my lord, it is appearing before my lord Justice Anana Bandhavadhyay. My lord Justice Bandhavadhyay was pleased to go out of the list. Thereafter, my lord, he is listing this matter before your lordship. Now he is absent.
Whether any order is there?
Several orders are there.
আমার ইয়েতে কোনো অর্ডার আছে? আমি পাস করেছি।
On the last order, Your Lordship, kindly see, my lord, the matter was gone out of the list because of their non-appearance several times.
Record reveals that on 23rd June
Kindly come to the facts first. Paste
high official says this is enforcement also urgent matter.
Subject matter of the petition, show cause issued against the petitioner, who is the chief manager of the UCO Bank. Now, what has happened? Allegation is that, my lord, he is indulging some customers, my lord, getting in the process of getting loan. What has happened thereafter? My lord, charge sheet has been issued, and departmental inquiry has been started, and order of dismissal was passed against the petitioner. Now, challenging the order of dismissal, the petitioner moved a writ petition. The first round of litigation order is at page 39. This is the order dated 8th March 2016. Which is at page 39.
Yes.
In this order, after hearing the learned counsel appearing for the respective parties, the Honorable High Court, which is at page 44, the operative part of the order. Kindly see last paragraph.
Yes.
The disciplinary authority, by its order, found all three charges leveled against the petitioner were proved. As aforesaid, the charges were based on the allegation imputed
against the petitioner, this court has already found finding on proof of allegation number 1 to be perverse. So far as the allegation number 3 is concerned, the allegation by itself did not impute misconduct by the petitioner. The disciplinary authority, by taking allegation number 1 as partly proved and the rest of the allegation as proved, considered that all the charges leveled against the petitioner were proved to award the penalty. In the circumstances, the court is unable to segregate the portion of the order of the disciplinary authority regarding the findings against the allegation number 2-4 and the charges in relation thereto. It appears the point of admission was not taken before the disciplinary authority but urged before the appellate authority, as that the authority below had failed to take the same into account. The point regarding the allegation number 3 relating to error of the judgment was taken by Mr. Mojumdar in arguing the writ petition on behalf of his client. Therefore, this court thinks it fit to set aside the appellate authority order and for the said authority to revisit the matter and dispose of the same as early as possible. The writ petition stands disposed of. Thereafter, the authority again passed an order which is at page 46.
Yes.
Again affirm the order of the disciplinary authority, which is dismissal of the petitioner.
Yes.
Challenging the said order, again the petitioner moved this Honorable High Court by filing a further writ petition. The order dated 7th November 2019, which is at page 61. Kindly come to page 61.
Yes.
After prolonged hearing and after considering the submission of the respective parties, the Honorable High Court set aside the order of dismissal. Kindly come to page 71, page 71, that is the operative part of the order.
Yes.
Paragraph number 21. For the reasons discussed above, the impugned order of imposition of penalty of compulsory retirement is set aside and quashed. The respondents are directed to reinstate the petitioner with all continuity of service upon imposition of penalty of reduction of his basic pay as directed by the DA in its order dated 1st September 2008 pertaining to the charge number 2 and start payment of petitioner's monthly salary and other allowances month by month within a period of 4 weeks from the date of communication of this order. The order dated 12 May 2017 passed by the appellate authority is accordingly modified and the amount already paid towards gratuity and provident fund shall stand adjusted with the petitioner retirement benefit. Thereafter, in the next paragraph 22, there can be no precise formula of cast iron rule for the grant of back wages upon reinstatement. The petitioner lost his job from the date of imposition of the penalty of compulsory retirement and presently he is on verge of the retirement. There is no allegation that he was gainfully employed during the period in question. The dispute among the parties had continued for substantial period of time and the bank cannot be held responsible for such effects of time, and it is not a case that the inquiry was held as a to get rid of the petitioner to victimize him. Then paragraph 23 in the said conspectus, the justice to be served through issuance of the direction upon the respondents to disburse 50% of the back wages.
50%.
The petitioner. Accordingly, the respondents are directed to disburse the said amount within period of 6 weeks from the date of communication. After the order of
the authority has not challenged this order.
Yes, order challenged before
Or
the division bench.
challenge.
Page 73.
Page 73.
And kindly
We
see
do not
the-
find any reason to just interfere.
Page-
So order affirmed.
Affirmed.
Order
But side-
affirmed. Yes.
Order affirmed and kindly.
Now you prayed to release the benefit in terms of that order.
After the order passed by the Honorable Division Bench,
Division,
I
but
joined
they have
in the-
not. They have not given.
Yes, I joined in the service. Rejoined in the service from the dated, my lord, কবে join করেছিলাম? 27 January 2020. The petitioner joined in the service. After that, petitioner want some benefit from the authority that has not been given thereafter, kindly come to the some order passed by this in the writ petition by this honorable court. Kindly come to the order dated 1st December 2021.
In this writ petition.
In this situation. Order dated 1st December 2021. আমাকে একটু মিটিং এর ওটা দিয়ে দাও।
1st December 2020.
Old writ petition.
দেখুন তো 1st December 2020. What order was passed?
Order was passed. The honorable court framed some issues and give a direction upon the authority to sit with the petitioner, and certain point has been framed by the court and to decide that petition whether petitioner is entitled to get all benefits or not. Kindly come to the order dated 1st December 2021.
Yes.
After hearing the parties and considering the exception taken by the petitioner to the computation submitted by the bank and affidavit in opposition filed by the bank to the exception taken by the petitioner affirmed on 23rd November 2021 and filed in court today, which is taken on record, I find before any order can be made, the court should be provided the following facts and figure. What are the facts and figure? As on date of suspension, that is 1st September 2008, what was the scale of pay of petitioner? Second point, what was the amount of monthly salary of the petitioner was receiving with the as on 1st September 2008? When point number 3, when was the revision of pay allowance in respect of the petitioner took place after 1st September 2008? And what was the amount of basic salary receivable by the petitioner on such revision? Point number 5, was there any subsequent revision of pay and allowance of the petitioner after the first revision, if any, till the petitioner joined the service of the bank on being reinstated, that is 27th January 2020, treating his service to be in continuity? Because in the order passed by the Honorable Justice Tapobrata Chakraborty, there is mentioned that he is entitled to get benefit of continuity of service. Now, point number 6, what was the salary receivable by the petitioner on and from 1st September 2008, month by month, with revision and breakup till 27 January 2020, after reducing the petitioner basic pay as directed by the disciplinary authority and confirmed by the order dated 7 November 2019. 7 point, what is the amount of leave salary to which the petitioner is entitled upon his services being reinstated with all continuity of service? And is the petitioner entitled to any stagnation benefit? And if so, to what extent? Then the meeting was held between the petitioner and respondent authorities. In the meeting, the minutes of meeting has already been
handed over to you.
Handed over to me, and also I submitted before the court also.
Supplementary affidavit.
Is attached with the kindly come to an this one. According to query number 1, as on date of suspension, that is 1st September 2000, what was the scale of pay of the petitioner? It is such and such amount. Now, what was the amount monthly salary that has mentioned? 41,000.
Take up calculation of his.
Point number 3, when was the revision of pay and allowances in respect of the petitioner took place after 1st September 2008? That is, after 1st September 2008, revision of pay was done with effect from 1st November 2012. Then what was the basic salary and petitioner on such salary has been mentioned 71,000, the gross pay 71,527. Was there, regarding point number 5, was there any subsequent revision of pay? They are saying that there was no further revision of pay and allowances to the petitioner. Regarding point number 6, what was the salary receivable for the petitioner on and from Atho? Salary receivable by the petitioner on and from 1st September 2008, month by month, with revision and breakup till 27 January 2020, after reducing the petitioner basic pay. Now, point number 7 is what is the amount of leave salary petitioner is entitled to get leave salary according to them 27,811 and odd. And is the petitioner entitled to any stagnation benefit? Yes, the petitioner is entitled to stagnation increment. They have stated. After the meeting, the order, kindly come to the order dated 10th January 2022. Right?
Page
10th January order dated 10th January, which is at O in this petition.
About 10th January 2022. Yes.
Kindly, by an order dated 1st December 2011, I had directed the petitioner along with his advocate and representative of the UCO Bank, being the respondent number bank, allowing his advocate to attend a meeting before the Assistant General Manager, Staff Pension and Terminal Benefit Cell of UCO Bank, being the respondent number 5. The said respondent number 5 has held a meeting on 14 December 2021. A copy of the minutes, that's minutes I have just read, on perusal of the minutes of meeting dated 14 December 2021, and after hearing the parties, I find that there is no dispute with regard to the query number 1, 2, 3 and 4. So far as query number 5 is concerned, the bank has agreed to pay difference area due of revision of pay from 1st November 2017 to 26 January 2020 after approval of competent authority. The petitioner says that he is agreeable to the period for which the revision of pay has been agreed to be granted by the respondent bank. With regard to the query number 6, the bank has agreed to amend the month of stagnation increment and recompute the arrear accordingly. The bank has not carried out the recomputation till now. The petitioner says that only after recomputation is made, the petitioner will be in a position to say whether the same is correct or not. In respect of query number 7, the petitioner admitted to have received 72,811, says that he is entitled to encash the leave available to him prior to his compulsory repayment. The bank has, however, disputed this contention by saying that whatever leave salary the petitioner was entitled to has been duly paid to him. That is rupees 72,000 and odd is the full and final figure which the petitioner is not agreeable to accept. Now, regarding stagnation benefit, the aforesaid facts and circumstances, I direct the UCO Bank to pay the petitioner the difference of area due revision of pay from 1st November 27 to 26 January 2020 within a period of 7 days from the date, and no further notice or demand should be made as the bank is represented by an advocate. With regard to stagnation increment, the bank is directed to recompute the arrear within a period of 7 days from the date and supply a copy of the petitioner on or before 19 January 2022. So far as the leave encashment is concerned, UCO Bank shall file a report in the form of an affidavit affirm that a responsible officer of the bank giving on the basis of the calculation of rupees 72,000 and odd said to have been paid by the respondent bank to the petitioner, and the reason for which the petitioner is not entitled to any further sum on that account. The report in the form of an affidavit shall also include the stance of the bank. As so far as the claim of the LTC made by the petitioner in the instant writ petition, there is a direction for further exchange of affidavit.
Thereafter, what happened?
Thereafter, kindly come to order dated 7th March 2020. In every order, some benefit is given to the petitioner in respect of different head. page 7th, order dated 7th March 2022. আমরা কি কেটে দেখাচ্ছি তো পরপর?
Yes.
By the said order, this honorable court was pleased to there, my lord, it is regarding leave encashment. Kindly see, after dispute having been resolved through a joint meeting, only issue which is outstanding in this matter is the petitioner entitlement of leave salary. By a judgment and order passed dated such and such, the petitioner was reinstated with continuity in service upon imposition of penalty of reduction of his basic pay as was directed by the disciplinary authority in its order dated 1st September 2008. The moment the petitioner was reinstated with the continuity in service, the petitioner says to have become entitled to the benefit of all his past service. That is the contention of this honorable court. The bank preferred an appeal. The appellate authority upheld the judgment and order dated 7th November 2019. The bank has not challenged the order of the division bench. The order of the learned single judge as upheld by the division bench has achieved finality. The next page, the petitioner therefore, accordingly to me, is entitled to leave salary with regard to the leave for the entire stretch of the service. That is from 1985 when he was appointed till his superannuation on 1st July 2020 is to be considered to be continuous. The bank says that petitioner is entitled to leave salary only for 19 days privilege leave, being the balance at the time of retirement as per the statement of the bank appearing in paragraph number 6 of the report affirmed on 1st February 2022. The petitioner, by taking exception to such report, says that 19 days period is only for the period when he joined on the basis of reinstated, that is after joining of the petitioner and his rejoining of the petitioner in the service and his superannuation on 31st July 2020. The petitioner is entitled to more days of leave salary. In the aforesaid fact circumstances of this case, for circumstances, I direct the respondent bank to give complete details of leave the petitioner was entitled to between 1985 to 2020 on year-wise basis, and for the number of days in each year the petitioner has availed the leave. The bank shall also indicate the total number of days for which the petitioner was entitled to leave during the entire service tenure between 1985 and is joining on being reinstated, and the total number of days of leave the petitioner has availed during such period. The respondent bank shall also indicate whether there is any gap of in regard to maximum number of days for which an employee of the respondent bank is entitled to leave salary. These details should be furnished in the report in the form of affidavit to be filed by 25th March 2022. On the next day, the next order, that is dated 30th March 2022.
Yes.
The order by an order dated 7th March 2022, the respondent UCO Bank was directed to give complete details of the leave the petitioner was entitled from between 1985 and 2020 on year basis, and for the number of days in each year the petitioner has availed the leave. It is submitted on behalf of the UCO Bank that the records being voluminous and the details could not be made ready within a scheduled time, and as such an
They took
extension
time. Whether they have filed the report.
Report, kindly see, they failed to file any report regarding leave. Now page 20.
They have not filed.
No, kindly come to.
So you file the report.
No, kindly come to order dated 2nd May 2022.
My learned friend is placing what they have received till date. What they have not received, that is not yet placed before lordship. Let my learned friend place what he has received.
I complete panel one by one, because certain benefit petitioner demanded before the authority. Certain benefit has been given by the order of this honorable court after rejoining in the service, and some
actually what this order sheet suggests that the coordinate bench tried to shorten the area of litigation. He initially identified 7 points, 7 places to be addressed, and then one by one he stated that petitioner grievances have been redressed and redressed, and the only grievances is yet to be redressed is that their leave salary.
That is also
Now-
paid. That is also paid.
Now there is a confusion regarding the issue whether he has, petitioner has been given the full benefit of leave encashment.
That has not been given because, my lord, there is a direction by the
Yes.
single bench, 50%
So
back wages.
dispute still lies.
Still lies.
Still lies. And considering this fact that court asked them to file a report giving the details of the leave he has taken. And his 300 days, his entitlement
Leave
300 days.
salary already paid. Entire leave salary paid. Initially, there was a
That's why
dispute.
the order dated, my lord, 2nd May 2022.
I can show your lordship from the.
What is fact is issue? Section 3 of the evidence. When one person asserts something, another person denies something. Okay. Okay. So dispute is lies. Dispute of the question whether leave salary or total was
According
total
to-
paid to the petitioner or not.
My lord,
Now,
as on date.
as on
And
date.
it is already recorded in the order, my lord. Your lordship kindly get from the earlier order from the coordinate bench. Bank has already paid 95 lakhs 40,006.
I am entitled to.
This should
I-
not
if
be
I-
the summation. So what? What I have paid, I am
entitled to
submitting.
Get more.
What
Why,
more?
when Mr. Chatterjee
95
was making submission, why court interfere and said?
They let
Court said that the coordinate bench asked you to file a report detailing the leave. He availed of, and it was in its credit on the date of his retirement.
My lord, we are not disputing on leave salary because we have lost the record. Initially, they have claimed that the bank has paid 72,000 and odd. That is their leave salary. Thereafter, my lord, on 22nd June 2022, bank has paid another 9,72,680 as leave salary. We have already paid leave salary.
That is by the order of the, after the order of the honorable court. That's why I am.
Yet he is not satisfied.
Well, leave salary.
Leave salary for how many days he will get?
There are, my lord, different heads, my lord, petitioner demanded.
Well, let my learned friend say whether any leave salary he is claiming or not. Let my learned friend say, submit that whether any leave salary is pending or not.
But I am submitting, my lord, before your lordship, what benefit petitioner got.
I am
No.
Lordship is asking
The
whether leave
area of-
salary is pending or not.
Again, excuse me, my reputation. The area of litigation has been sorted and narrowed down by the coordinate bench.
Kindly come to, my lord, the order
Want to
dated.
extend.
Kindly ordered. I am not one. I did not want.
So now you kindly come to
Come to order dated 2nd May 2022.
Okay, I am coming. I am coming. Before that, you. In which order the
March
court
2022,
that
where, my lord, the order.
the outstanding, the only question is outstanding to be.
Which is discussed before the between, well, honorable court was pleased to make out some point. 8 point. Not that entire demand of the petitioner has already been decided by the authority. In the writ petition.
You have not challenged any of the order.
Why? Well,
You have not
the 8 point
you have not challenged and filed any application paying for modification or recalling. The court observed that there is no dispute with regard to the query number 1, 2, 3, 4. You have not challenged this order. Now you will not
admittedly,
be.
one
You are
report regarding point
you
number
are stopped from reopening this issue.
What point number 1 regarding the quantum of my salary? I am not disputed that.
You will not be able to raise any issue except your leave salary.
Kindly come to my
Because the principle of res judicata applies in course of proceedings also.
Absolutely.
You are stopped.
My lord, kindly
You have not challenged. You just say leave salary. Otherwise, I say court will not allow you to raise this, any other issue.
I am, my lord, giving reply, my lord, kindly go through, my lord, the order dated, my lord, 2nd May, kindly consider 2nd May 2022.
Okay, whether you have filed report.
I do not file any report, my lord.
Oh, you file report.
No, my lord, please, my lord. My
You
lord,
comply with order of the coordinate bench, then
my lord, kindly see, my lord, kindly consider his affidavit, my lord. That is, ছোট আর করিস না, অনেক বড় করে দিয়েছিস, শুরু করেছিস সে একদম রামায়ণ মহাভারত
My
শুরু
lord,
কি
in terms of
পাসনি
the order
সেটা
of
বল।
the honorable court, my lord.
My lord, is
dated, my lord, this is
18 February 2025, his affidavit.
My lord,
On affidavit, he is saying leave salary has been paid and he has received the leave
I
salary.
am not raising any objection regarding.
My lord is
leave
concerning
salary.
about only leave salary. Your lordship kind.
Raising the case regarding the leave, what steps has been taken by the authority, what benefit I got from the authority. And what is my ultimate demand in the writ petition? I kindly come to the order dated second, order dated 2nd May 2022, wherein, my lord, regarding the honorable court, my lord, was pleased to give me direction upon the authority to file their affidavit in opposition regarding other demands of the petitioners and outstanding dues. And they comply the order, they file the affidavit, and I already exchanged affidavit in reply. What is that? Seriously, that কি আছে বর্তমানে?
okay, have you filed the affidavit?
My lord, yes, my lord, affidavit.
They have filed.
My lord,
they have filed
kindly
their
consider his affidavit. On by
Oh.
virtue and order of my lord Justice Orna Bandyopadhyay, he has filed this affidavit and lordship
And have
kindly.
It is supplementary affidavit, okay.
Yes.
Have you filed your response?
Yes.
No,
My lord, kindly come to my lord Annexure B, my lord. Kindly come to Annexure B.
No,
page eight.
have you filed in affidavit in terms of the order dated 2nd May?
They have filed their affidavit in opposition. I filed my affidavit in reply. Thereafter, my lord, the matter appeared before the Honorable Justice Ananda Bandyopadhyay, dated, my lord, the 5th December 2024, whereby the Honorable Court was pleased to give direction upon me to file a supplementary affidavit detailing the outstanding due of the petitioners.
No.
Kindly come.
Direction was there. What you have received, kindly stay on affidavit. That is that affidavit, my lord. Kindly see page 8, page 7 and page 8. Page 8, he said that, my lord, clause 5, leave encashment. The petitioner received the amount of leave encashment on the basis of earlier gradation of pay. He has already received the leave encashment.
Leave encashment I have received. I am not denying.
Of how many days?
My lord is only asking about leave encashment.
Of how many days?
139 days. Kindly see the mention. It is mentioned in the order dated 2nd May.
This statement you made on affidavit. On affidavit that 139 days only you have received.
Kindly see the order. Kindly consider the order.
Mr. Chatterjee, you are most probably you are taking the risk.
No, kindly.
Petitioner.
It is mentioned in the order.
The court has said
they are unable to the accrued in favor of the petitioner from it appears. Kindly come to second paragraph of the order dated 2nd May 2022. 2nd May 2022.
Okay, so they have filed supplementary affidavit.
Affidavit disclosing that what benefit I have received.
They have filed.
I have filed.
Yes.
Now,
so you filed your response?
No, I have already responded. I have already responded.
I have
already responded.
And whether you have filed affidavit in opposition in terms of the order dated 2nd May.
2nd May of
yes, they have filed.
Yes.
They have filed, and I also used reply.
Okay.
And yes,
the supplementary affidavit you have filed today.
No, I filed earlier on.
I have filed.
I have not filed this response to this affidavit. I do not want to file any affidavit. I will respond on this affidavit.
Okay. Mr. Somen Das, learned advocate appearing for the respondent bank.
Luxury litigant, my lord.
Luxury litigant. He will go on wasting the judicial hour. What can be done?
Luxury
Petitioner is
litigant.
fighting for his entitlement. Legal entitlement, my lord, because my lord, he, my lord, vindictive malafide, my lord, a disciplinary proceedings has been initiated.
Thank you.